So we're going to start off, we haven't gavelled in yet, but if Mr. Cook, Zephyr, Mr. Shaw, if you want to come on up. No, we're not starting. I haven't gavelled in yet. I'm just letting him know so we can get started right when okay, the Senator gets here.
You're broadcasting though.
I understand. And then all right, hold on one second. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, February 18th, 2025. We have 8 bills on the docket. We're going to start off with Senate Bill 677, Senator Guile. Senator Guile, we have 2 of your panelists up here. Would you like anyone else for your sponsor panel?
Yes, Mr. Chair. I believe we also have one by virtual, Adria Crutchfield from Baltimore Regional Housing Partnership. She's also on my panel. Yeah.
You got Mr.
Anybody else, Spencer?
And we've got Mr. Shaw and then Mr. Cook. We'll go second after the Senator. And I also have Albert Turner signed up to testify in favor, and Liz Kruger.
Liz Kruger as well. Okay. That's fine. What's that? Okay, it sounds as if somebody else might be joining, but it's running late. So we'll just go ahead and get started.
Sounds good.
Thank you very much, Mr. Chair, Mr. Vice Chair, members of the Senate Judicial Proceedings Committee. For the record, Senator Don Guile, District 33, here to present Senate Bill 677. This bill would bar landlords from refusing to rent to a prospective tenant who pays rent with the assistance of an income-based housing subsidy on the basis of the prospective tenant's income, credit score, lack of credit score, or adverse credit history. By way of background, the use of credit scores is a screening tool for tenants with housing assistance and is both unnecessary and results in the discriminatory exclusion of these individuals from quality housing for which they would otherwise qualify. While considering income and credit score on its surface may seem like a reasonable requirement, further thought does not support the necessity of doing so. Public housing authorities already conduct comprehensive income verification and affordability assessments for housing assistance recipients. Because of this oversight and the fact that rental assistance ensures the rent is covered even in the event of income fluctuations, additional income and credit screening by landlords is redundant and serves only to create unnecessary barrier and a legally allowable way to exclude voucher holders from housing. Failure to acknowledge the unique guarantee of rental payment that rental assistance provides has real consequences for real people in this program. a single mother who finds herself struggling with her credit after her divorce, but who prides herself on having never missed a rent payment in 20 years, or a family whose child lives with a chronic condition, falls behind on medical bills, but prioritizes housing stability for their family's health. The use of credit scores and tenant screening has a disproportionate negative impact on Black, Latino, and low-income renters, reinforcing systemic racial and economic disparities. According to an analysis from the Urban Institute, the difference in median credit scores between predominantly white and non-white areas is nearly 80 points. In their analysis of Baltimore specifically, they found a median credit score of 671 in predominantly white areas and 576 in non-white areas. Increasing access to stable housing fosters stronger communities and leads to improved outcomes for families that ultimately benefits the entire state. Families with young children moving from high poverty areas to resource-rich communities have been demonstrated to especially benefit, with children having higher incomes and being less likely to themselves live in high poverty areas as adults, disrupting cycles of intergenerational poverty and investing in the economy of opportunity our state needs. Under the existing law, landlords are already barred from discriminating on the basis of the source of a prospective tenant's income. In other words, if a prospective tenant pays rent with the assistance of an income-based housing subsidy, a landlord may not refuse to rent to that prospective tenant solely on the basis of their status as a voucher holder. However, income and credit score requirements can be and have been used to screen out voucher holders by landlords. Senate Bill 677 would bar landlords from refusing to rent to a prospective tenant who pays rent with the assistance of an income-based housing subsidy on the basis of the prospective tenant's income, credit score, lack of credit score, or adverse credit history. It would also make clear that landlords that receive funding from a governmental entity, a quasi-governmental entity, or a nonprofit organization that requires income qualification for tenants in income-restricted rental units may collect financial information from a prospective tenant if the collection of financial information is a condition of the funding. And for all these reasons, I respectfully request a favorable report on Senate Bill 677.
Chairman, members of the committee, thanks for having me here. For the record, my name is Chuck Cook, Chief Legislative Officer for DHCD. I want to thank the sponsor for putting the bill in. We actually worked with Senator Guile over the interim on this bill. Pretty excited about it. First of all, I want to thank you, Chairman, for your leadership in 2020, specifically by introducing and shepherding through the General Assembly the Housing Opportunities Made Equal Act, otherwise known as the HOME Act. It was a huge step in providing protections for our most vulnerable renters and their families. As a refresher on that legislation, the HOME Act prevents landlords from refusing to rent to a prospective tenant because he or she receives, for example, housing vouchers or Social Security benefits rather than income from employment. Since its enactment, the HOME Act has helped ensure fair access to housing for individuals with non-traditional income sources by giving voucher holders access to more housing options and a wider range of neighborhoods. Some landlords, however, circumvent the HOME Act by enforcing minimum income requirements or credit score requirements, including against prospective tenants who receive housing vouchers, even when those vouchers fully cover the cost of rent. While technically legal, this practice amounts to a de facto source of income discrimination. Senate Bill 677 removes this loophole from the law by prohibiting landlords from considering the income or credit history of a prospective tenant who pays rent with the assistance of an income-based housing subsidy. And by addressing these discriminatory practices, SB 677 will help ensure fair access to housing to more Marylanders and help some of the state's most vulnerable residents obtain stable housing. By enabling voucher holders to live in a wider range of neighborhoods, the bill will also help deconcentrate poverty and promote socioeconomic mobility. So for these reasons, the Maryland Department of Housing and Community Development respectfully requests a favorable report on SB 677. Thank you.
Hey, good afternoon. Chair Smith, Vice Chair Waldstreicher, members of the committee, Zephyr Shaw for the record on behalf of Maryland Legal Aid. We urge the committee's favorable report on SB 677. We thank Senator Guile for bringing this bill. I want to give some life to what you've heard about already, talk to you about our client, Holly Hickman, a renter in Frederick County who has an intellectual disability. And with the support of the ARC of Frederick County, she cares for 3 adult children with disabilities and a newborn grandchild. And their family makes ends meet with Social Security income and a housing voucher. Last March, they received a lease non-renewal notice and scrambled to figure out what to do next. I was really shocked and scared, she recalls. Her troubles were just beginning. Holly describes to Legal Aid how difficult it was to find a landlord who would accept her housing voucher. She told us, "I applied to so many places and was rejected from all due to things on my credit report. Every application was so expensive. I paid $100 to $160 for every application. And then they would reject us. I would not get that money back." Maryland Legal Aid worked with Holly and the Housing Authority to extend her voucher from 60 days to move it to 6 months. It took that long for Holly and her family to find a landlord who would accept her voucher. But before that happened, they ended up homeless, living in a hotel for 9 days. Holly understands that her credit history was not good. She had been in an abusive marriage. Her ex-husband racked up credit card debt that affects both of them. Holly wants you to know, I can afford my rent with my voucher, and I did not owe any rent at the time that my lease was non-renewed. And that's what should matter when she's in the tenant screening process. That's what this bill requires. We urge your favorable report. Thank you.
Thank you, Mr. Chair. Mr. Vice Chair, members of the committee, against Matt Hill, Public Justice Center, stepping in for Albert Turner. And first, I just want to thank you, Mr. Chair, and the committee for passing the HOME Act in 2020. And it's incredibly important that all people have access to fair housing opportunity. And the bill is having a significant effect. We're seeing more folks with vouchers having less difficulties finding housing. However, not here just in Maryland, but across the nation, landlords are adapting and they are finding ways to circumvent those protections, including by imposing income and credit score criteria on folks who have vouchers. And I just want to, similar to what Mr. Shaw's testimony, tell you a little bit about one of our clients who is based here in Annapolis. A mother, also fleeing domestic violence, had an emergency Section 8 voucher, which was going to pay her rent in full. So in other words, her share of the rent was zero. The voucher paid her rent in full. She put in 20 different applications and was denied all 20 times. She took her 6 months to find a landlord who would take her voucher. Each time the landlords told her that she did not meet the income and credit score criteria for their application. If the HOME Act is going to have any teeth, if it is going to be effective, then a bill like this has to pass, and it has passed in states like Colorado, California, DC, a number of others. Other states have issued regulatory guidance from their attorney general saying, you know, look, these kinds of practices circumvent the remedial purpose of the source of income law, and they have to stop. So with that, we'd ask for a favorable report.
Excellent. We'll switch over to our panelists joining us virtually, and then we'll open it up for questions. What's your name? Ms. Crutchfield, you're welcome. You're up.
Mr. Chairman, Vice Chair, my name is Adria Crutchfield, Executive Director for the Baltimore Regional Housing Partnership, and I thank you for the opportunity to testify today in strong support of Senate Bill 677, which seeks to protect recipients of housing assistance from exclusionary rental screening practices. BRHP is a nonprofit organization serving as the regional administrator for the Baltimore Housing Mobility Program, which provides over 4,300 low-income families rental assistance and housing counseling as they transition from areas of concentrated poverty to areas of opportunity in Baltimore City and the 5 surrounding counties. The widespread use of credit scores and credit history in tenant screening poses an undue barrier and results in the discriminatory exclusion of individuals from quality housing for which they otherwise qualify because it ignores the financial security of the housing subsidy, which goes up or down as the tenant's income goes up or down, and excludes qualified tenants based on factors unrelated to their ability to pay rent. Taking a sample selection of 250 of our participants, we found an average credit score of 587, a score that restricts access to many traditional rental options. But for these assisted families, the score provides no relevance to the landlord's likelihood of receiving their monthly rent. Failure to acknowledge the unique guarantee of payment that rental assistance provides has real consequences for participants in our program. While these families that Senator Giles referenced in her opening remarks were eventually able to find housing with the help and support of BRHP's housing counseling team, their struggles to find housing for which they qualified extended their housing search times. It's important to note that credit scores for these families generally fail to reflect their history of on-time rental payments, as rental housing operators rarely report this information to credit bureaus. HUD has stated that HUD is aware of studies showing that credit reports and scores accurately predict a successful, unaware that credit reports, and scores accurately predict a successful tenancy. Further, the legislation does not prevent landlords from using more relevant tenant screening like rental history to determine whether a prospective tenant is a risk. The practice of not using tools like credit screening when more relevant information is available is specifically encouraged by HUD as a practice to ensure compliance with the principles of fair housing and anti-discrimination. At the same time, it's worth noting that participants in housing assistance have additional oversight and are required to pay their share of rent or risk losing their housing assistance.
Excellent. Thanks. Just very succinctly,
urge the committee to please pass this bill. Thanks for your time.
Excellent. No, thank you very much. All right, we're going to turn it over for questions from the committee. First, I'll say, Senator Sidnor and I can go on this to really thank Senator Dolores Kelly. She championed the HOME Act for years before I sponsored it and we were able to get it over. So I just want to make sure we give credit to where credit's due, because she did the work for, better part of a decade for that bill to pass. How many voucher holders are there in Maryland? Does anyone know? We're trying to figure this out. If you don't know, don't worry about it. We'll figure it out.
We'll get back to that
Yeah.
information. I think it's over 50,000, but.
Wow, it's incredible. All right, Senator James.
Thank you, Mr. Chairman, and thank you all, Senator Giles and everybody, for an excellent panel. I'm not really familiar with this area, so as the chairman indicated, I would like a little more information. We may have 50,000-ish people that have housing vouchers. So is there any study or evidence or record keeping about the nature of their tenancies? Do they, percentage-wise pay their rent in a timely fashion, and things like that? And then, is the prohibitions you're seeking here? Let me try to think. I always think information is power. So I guess I have two questions. One, what would prevent any landlord, I'm thinking more mom and pops like myself, from going ahead and just asking paying themselves and getting a credit report? And also, what is the demonstrable benefit do you think? In other words, I'm not sure if getting this information or now banning it is what will make the difference. I could be really wrong because I don't know the data on how those tenants pay their rent, how reliable they are, and a whole host of other things. So just matching up this effort, I think somebody mentioned it might be going on in another state, and you do believe there's some data to show, I don't know, more tenancies. But I guess I'm trying to figure out how many tenants with this option, this subsidy, are regularly not able to rent and are basically homeless, or I just don't know anything about it. So a lot of questions, a lot of follow-up. The data after the hearing would be helpful.
Excellent. Ms. Crutchfield also wants to join in after the senator, yep.
Yes.
You know what, Mr. Chair, I would actually, I believe Ms. Crutchfield could probably answer some of Senator James's questions. I think
you.
she had her hand up, so Ms. Crutchfield.
You can also follow up
go ahead.
afterwards, too. It's a lot
I
of
think she may be
questions.
now frozen, hold on.
Oh,
She had her hand up, though, I did see that.
oh, good. Well, follow up.
All right, she's frozen.
Oh, she's frozen now. Or maybe Mr. Cook.
And then you all can follow up in writing, that'd be fine.
So, yeah, Department of Housing and Community Development, we have data on a lot of this.
Good.
Fortunately, to the first question about how many voucher holders there are complete, that HUD would know that. We are the public housing authority for parts of the state, but then also a lot of localities
Are
have
you
it
in
too.
a better
and they-
position than
they
I am to
direct
get that HUD
information.
data? Because
Yes, yeah.
I'm in a better position to do that?
Yeah.
Do you know where I find it?
No, I can absolutely follow up with you.
Oh, okay.
The series of questions too that you had, and
Thank
also the addition of how many voucher holders there are in the state. Okay?
Thank you.
Yeah, absolutely.
All right,
Happy to
great.
send it.
Thank you.
Further
questions from the committee? All right, Senator? Yep.
Mr. Chair, if I could just add too, by the way, there were some, I forgot to mention earlier that there were some technical amendments that were requested by the Maryland Commission on Civil Rights. We submitted those to the committee as sponsor amendments. So I just wanted to flag that for the committee. So thank you, Mr.
Excellent.
Chair.
Ms. Crutchfield, if you are back online and you remember that line of questioning you would still like to answer, I'd like to provide you with an opportunity to do so.
The number of voucher holders, we can get back to you on in Maryland. But in terms of the impact that the screening has, so just a couple things to keep in mind. When applicants apply, they have to pay a fee. Folks who have very low incomes already don't have sufficient funds to just pay application fee after application fee, only to then turn around and be denied because of a credit score. We also find that these leasing offices are averaging credit scores for all adult members. That's another thing that we don't think makes much sense, given that the subsidy is tied to a member of the household, the head of household, as opposed to anyone else. Obviously, everyone's income is calculated towards, what the tenant portion would be, in addition to what the rental subsidy would be. And yes, the two places that we mentioned have already done this are Colorado and DC. I believe California as well. I'm not sure which jurisdiction or if that's statewide. So the impact that it has basically is keeping applicants who, again, otherwise, we are going to pay on the first of the month very reliably. And I think a lot of folks saw this during COVID on behalf of these tenants. And their portion is up to 30% of their income. So they pay that as well, right? But the fact of the credit score screening, keeping families even from further consideration, really is a burden to them. And that's after, an application fee has already been taken. And it just leads to a much longer housing search time. And these families have a limited amount of time to search for housing.
Can I just, thank you, Mr. Hopefully you heard my line of question because you weren't able to get to all of them. Please don't do it now. But I think everybody took notes on it. So I have kind of more specific questions. You generally helped a little bit. So I do think I want more information. Is that? Okay, thank you. Very good.
All right, seeing no further questions, thank you very much. All right, we'll now move on to the second round of proponents. Or actually, let's see. I think that'll do it for the proponents. We'll now switch to the opposition panel. And we'll go with favorable with amendments. Is Jonathan Smith here? Hey, there you are. Mr. Smith, welcome.
Good afternoon. Thank you, Chair, members of the committee. Jonathan Smith. I am Chief of the Civil Rights Division of the Office of the Civil Rights Division of the Office of the Maryland Attorney General. As you've heard, Maryland has very strong protections against discrimination in housing, but there's a gap in Maryland law that permits the use of credit scores for persons who use a voucher to pay rent in their housing. And the Office of the Attorney General supports this bill as a way to close that gap and make the HOME Act much more meaningful. Housing discrimination is a persistent problem, and Maryland remains highly segregated. Segregation has an impact on every aspect of life. The ability to live where one chooses affects access to nutrition or health care, defines what schools a student can attend, limits access to work and transportation, and impacts recreation and cultural opportunities. Voucher holders are disproportionately Black and brown persons and persons with disabilities. The housing voucher program emerged from a response to the racial segregation in site-based public housing. Nevertheless, voucher holders continue to be more likely to live in racially segregated neighborhoods, in part because of voucher discrimination. In addition, vouchers are utilized by the state itself in its programs to meet its civil rights obligations. In particular, state-funded vouchers are used to implement housing programs for persons with disabilities. The General Assembly extended protections against discrimination to include persons who use a government voucher to pay rent when it enacted the Housing Opportunity Made Equal, or the HOME Act, and thank you, Senator Smith, for championing that bill. The HOME Act contains, however, an exception for commercially reasonable and non-discriminatory considerations of credit worthiness. While we believe that a credit score for a voucher holder is not commercially reasonable, many landlords continue to use a minimum credit score to exclude voucher holders. This practice undermines the very purpose of the HOME Act. This bill makes clear that the practice of requiring a credit score for a voucher holder to apply for rent is illegal. For these reasons, we urge a favorable report.
So questions from the committee. We have Senator James, then Henson, and then I've got a couple questions.
Hi, thank you.
Hi.
I wanted
Good to see you
some.
again.
Hi, good to see you. Just a clarification, because I'm trying to understand if you're suggesting that what landlords are doing is trying to unconstitutionally discriminate against people of color, or are landlords, I usually think they're just about the money. So
Okay.
I'm wondering if they're, what they're doing, probably frustrating your purpose, but, they're basically just trying to cut or minimize any risk perceived in reality or just perceived in their minds. And this is just one of them. But are you making the claim that this is about racial discrimination?
I'm not making an assertion that there's a racial motivation to the conduct to exterminate voucher holders. The HOME Act was passed in order to make sure that persons who use a voucher to pay their rent have access to housing. And we've seen a range of strategies, including this one, as a way to get around the objectives of the HOME Act. And by setting a high credit score, persons who use voucher, almost by definition, if you don't have income to pay your rent, almost by definition, you're going to have an issue with your credit score.
What's the act called again? Sorry.
The HOME Act.
The HOME Act.
The housing, I will forget the acronym.
That's okay.
Yes. And that legislation prohibits discrimination based on the use of a voucher, and it has an exception for the use of commercially reasonable consideration of credit worthiness.
Okay.
So
I gotcha.
By setting a high credit score, minimum credit score requirement, and thereby excluding voucher holders, it has a disparate impact on people of color and people with disabilities.
But not,
so,
but
intent is not required under the law.
Right, colorblind, it hurts everybody that's poor.
It doesn't have, but disproportionately vouchers are used, and that's.
I just think wrong is wrong, so it does, to me, the percentages of who it affects, it's just wrong if it's wrong.
Oh, I do agree, but there is and that's the discriminatory impact. May well be a violation of both the federal Fair Housing Act as well as the anti-discriminatory provisions in Maryland, already in Maryland law. This statute will make clear that the practice is inappropriate and illegal without having to go through the more complicated analysis and often the expensive analysis for everybody about whether or not there's a disparate impact as a result of voucher discrimination.
You heard my questions earlier. If you have information that you think would be responsive,
Certainly.
not now, after the hearing, please follow up with me and send it to me. Thank you.
Yeah, thank you.
Senator Henson.
Chairman, and I apologize, I had a bill that I was presenting in another committee. I missed the first panel. So what's your familiarity with the way that credit scores are derived? Is it appropriate to ask you a few questions for understanding on that, or is there someone else I should follow up with?
I have some familiarity. We've been looking at this issue in the Office of the Attorney General. The first panel did discuss that question. I think there's some sophistication there that maybe I don't have, but I'm happy to attempt, and then you can maybe refer to someone else.
It's my understanding that there's some racial biases built into the credit scoring algorithms, and that certain groups of people tend to find themselves with lower credit scores. Some of the things that are built into the algorithm is the income of the persons that live around you in a certain radius. And so if you live within a higher concentration of poverty, then your credit score is artificially depressed. And there are other ways that the credit score might not be the best predictor of a person's ability to make timely payments on something. Is that an accurate understanding?
So about the precise calculation of credit score, I am not an expert. When you look, though, at credit scores and the use of credit scores across a broad range, either in the consumer credit context or in rental housing or purchasing a home, credit scores for persons of color are disproportionately lower than credit scores of white people. And it's particularly true that credit scores are concentrated in neighborhoods that are primarily black and brown neighborhoods. Credit scores of the persons who live in those neighborhoods are concentrated or lower. That probably has a lot to do with both the neighborhood, but the undervaluing of the homes, the issues around the values of rents, the kinds of access to banking and other credit and resources that might be available to people. So there's a very complicated set of discrimination that's already built into the economy that drives the credit scores of persons of color down. So you're more likely to have a lower credit score if you're a person of color. That said, in this context, anyone who qualifies for a voucher is already in a situation where they don't have enough money to pay their rent. They have to qualify, financially qualify for a voucher. So anybody who's going to qualify for a voucher is going to almost inherently have a credit score. It'd be very unusual for someone to have a housing voucher support and a very high credit score because the credit score is in part driven by your income. And so it's very likely that there's almost it's an empty set of people who would, if you set a high credit requirement for renting, it's almost an empty set of people who would ever be able to meet that requirement.
Thank you for your testimony. Thank you, Mr. Chair.
Further questions? So you're signed up favorable with amendments. What was your amendment?
There was the amendments that were recommended by the Maryland Commission on Civil Rights.
Okay.
It's essentially to move the substantive provisions into the anti-discrimination provisions where the Home Act is now.
Got it.
Out of a separate freestanding bill.
No, obviously, I was a sponsor of the Home Act, and so very much appreciative of the efforts and want to make sure that it's implemented to the fullest extent possible. But one of the things you started learning over the years of doing this is just like unintended consequences and inadvertently hurting the folks that you want to help. And I want to make sure that we're not doing that in any way, shape, or form. So I wanted to ask you a question about, so obviously in the scenario where someone is covered with 100% for their voucher, they're a voucher holder and their expenses are 100% covered, got it. Like credit score, payment history, any of that other stuff, understand. In the instance where there's a much lower percentage covered, and you're looking for the suitability or just the ability for an individual to maintain their rent so that they don't fall into the cycle of other things that we're talking about in terms of eviction proceedings and all the other unintended collateral consequences. If not credit scores or payment history or anything, what other metric should a housing provider use to determine the suitability of an applicant? And the reason I ask that, because here's another little vignette. I mean, this is anecdotal because I haven't seen any of the data on this, but last year we passed a bill, we limited, and I was a proponent of this and voted for this and argued for this, but we limited the deposit from 2 months to 1 month.
Yeah.
Okay. Which I think was a good policy. But anecdotally, and I haven't seen any data on this, I'm hearing people say, well, I'm going to take less risk now on a lot of people. And that's excluding a lot of people from the housing market that would otherwise be housed but for this additional cushion that was built. And so I'm just very cautious about understanding the kind of the wax and wane of all this stuff.
Sure.
So what other metric can a housing provider use to determine the suitability of an applicant to meet their monthly obligations so they don't spiral into an unfortunate cycle of eviction proceedings and the like?
Sure. I mean, there may be a range of tools that a landlord could use, like looking at their rental history, eviction history, whatever. I think that one of the things that this situation suggests is, and the District of Columbia just went through a very comprehensive process of amending its law to create a fair tenant screening bill, which gave everybody guidelines. It says you can look at this and you can't look at that. This is how you're going to apply it. And the rental market in the District of Columbia is vibrant and active, and a lot of people, are making a lot of money renting in the District of Columbia, where you've got very robust anti-discrimination provisions based on the use of vouchers and other provisions. And so I think that there may be in consideration in future years. I think this bill is essential to make the Home Act meaningful, about creating those same kinds of guidelines, learning the lessons from what the District of Columbia did and other places, to have a more comprehensive bill that really looks at where the guardrails actually are. But landlords can look at all kinds, can look at rental history. They can get recommendations from prior landlords. They can look and determine whether someone has been evicted previously or not. They can interview the person, understand their circumstances. They can talk to the folks at the Housing Authority. So there are other strategies. This is such an absolute barrier. The two strategies that we're seeing to defeat the Home Act are the use of a credit score that is impossible for someone to meet, and minimum income requirements that require someone to have minimum income for of many multiples of the total rent, rather than just the tenant portion. And there's a case in front of the Maryland Supreme Court right now that will address that issue, that those are the two strategies, and those are absolute bars. They don't allow anybody through them. And if you actually use reasonable mechanisms, you could, I think, address the concern.
No, thanks, I appreciate that. Look, I'm not being rude. I'm actually looking at my phone for this app because it's Credit Karma app. So I'm looking at my credit score and looking at the factors that go into it. Mm-hmm. And so, first of all, I appreciate this because when the opposition panel gets up right behind you, you're not going to get a chance to answer these questions. So I'm trying to get you on record to help explain and flush this out. So this is very good. So I'm looking at this, Credit Karma app, and a lot of the factors for the credit score are, payment history. Your income is factored into there because it affords that credit card company an opportunity to understand how much of a risk they can take on you, so how much credit they're going to extend. But the highest percentages is basically payment history, credit usage, like how much credit you're using, derogatory remarks, your age of your credit, and the total accounts you have open, and then hard inquiries. How many times have you applied for credit, been denied? So these are some of the factors that go into the Equifax and the TransUnion credit score. I guess my question is that and income, because I want to make sure, because this is going to be brought up in the panel behind you. Right. Those are indicators of your financial proclivities and your behaviors and your track record. And so that married with your income, why is that not a good way to determine whether someone is suitable to meet their monthly obligations? Because so that's what I'll just leave it at that. Yeah.
No, I completely understand. There may be a lot of reasons why someone was unable, and you heard some examples. Someone has gone through a divorce. Someone has an accident. There's a disability that occurred. There may be a whole range of reasons why someone might have come across financial circumstances. Just being poor is really, really hard. I mean, it's one of the hardest things to live while poor and try to make all your bills meet and what have you. And by definition, someone is going to be, have those circumstances if they're going to have a housing voucher. Very few people are going to just get a housing voucher because there's a one-life event that deprives them of an income. Not the least of which because the waiting lists are massively long. I mean, to get on a housing voucher takes you forever, and in the time that you're waiting to get on a housing voucher, you're living in circumstances where you don't have enough money to have a stable housing situation, and you can't have the rent. So the problem with the credit score is not so much that some of the underlying data isn't useful and might be interesting or helpful to know. It is unlinked to whether or not the person can actually pay the delta between what the housing authority is paying and what the total rent amount is. Because if you set it so high, it's like sort of unmoored to anything. It's really just a way to prevent someone from ever using that housing voucher. If you actually looked at whether or not the person could pay their 1/3 of their income requirement, so you could say, for example, I'm going to set a minimum rental requirement or income requirement that is linked to the portion that the tenant is paying, then that might actually give you some useful information about whether or not the tenant can pay that portion of the rent. But you already know that that's no more than 1/3 of the tenant's income. Just by being enrolled in the housing voucher program, the person is never going to pay more than 1/3 of their income. And so you already know that there is money coming into that household sufficient to pay the portion that the tenant is responsible to pay.
Excellent. I appreciate that. I want to make sure you had an opportunity to address those.
No, I appreciate that. Thank you.
Sorry. Oh, yeah. Do you have something on this one? Because I want to.
I just want to ask about a case.
Okay.
As a case. I'm sorry.
Okay, sure. Yeah, I'm going to get Senator Sidnor, then Senator West, and I'll come back down to Senator James.
Thank you. Under the Fair Housing Act, would this bill already be covered under federal law?
No, not exactly. To prove a violation of either for race discrimination or gender discrimination, disability discrimination, under either the Federal Fair Housing Act or under Maryland's anti-discrimination provisions in housing, one would have to show that there's disparate impact on the protected category. Then the burden shifts to the landlord to show whether there's a legitimate reason for the policy that has the disparate impact. And then the burden shifts back to the tenant to show either that that's pretext or it's not the least restrictive mechanism to meet the legitimate business interest. And so it's a case called Inclusive Communities that was in the United States Supreme Court that described how disparate impact, and I'll share that with the committee if that's helpful.
With low-income housing tax credit.
And the court there created this three-stage test of shifting burdens in order to prove it. So if I were to, as part of the Civil Rights Division, if we were to identify a landlord that we thought was that their practices had a racially disparate impact, we would have to go through that process to establish it. And I do believe the use of credit scores would meet that standard. Those are not easy cases. They're expensive for everybody. They require the use of statisticians and demographers to prove it. Might have to do some testing. There's a range of ways in which you have to be able to prove that case. What this bill does is it just cuts to the chase. It says we're going to make the Home Act meaningful by not forcing everybody to go through that three-part analysis.
And I'm guessing it would be fair to say that this particular Department of Justice, this particular HUD, is likely not interested in moving forth these types of cases anyhow, correct?
Well, I think it's actually the problem is worse, because what we saw in Project 2025, and we've seen attacks across the country, and we've seen what's going on at HUD right now. I mean, they're planning to cut 50% of the workforce at HUD, including the folks that do enforcement, is that there's actually going to be an attack on disparate impact theory, that there'll be an effort to try to overturn the Inclusive Communities case in the housing context, which is why it's important that we embed civil rights protections in Maryland law so that Marylanders can have access to those protections using Maryland law, where we've been relying on federal law for so long. Maryland law is very strong, but it has been somewhat dormant in the shadow of the federal law. Maryland law is going to come to the fore to protect Marylanders from discrimination.
And this body has done so when it has come to things like women's rights, but we seem to be missing the mark when it comes to things like civil rights. So thank you very much for that testimony.
Thank you.
Thank you, Mr. Chair, and I apologize. I was in another committee presenting a bill, and the question I'm about to ask may have already been asked. So if I ask it a second time, whoever asked the question before, come over and kick me in the shins, and I'll just go back home later on and watch it on the tape. So I'm looking at the bill, and on page 2, it says a landlord may not refuse to rent to a prospective tenant who pays rent with the assistance of an income-based housing subsidy. So it is correct, is it not, that in most of these cases, the subsidy does not pay the entire amount of the rent, but only a part of the rent?
So under the program, I don't know the numbers, the distribution of 100% rent paid by the housing voucher program or not. Under the federal program, a tenant who has income is required to pay 1/3 of that income towards the rent. And then the housing voucher pays more.
And how much the rent is for the apartment, the housing voucher might pay a small percentage of that or a very large percentage, and maybe the whole thing, correct?
In my experience, the housing vouchers pay most or all of the rent. It's very rare that a housing voucher would pay a small portion of the rent just because of the way the housing voucher, the programs work. They prioritize families with children, persons with disabilities, people who have the most extreme need for a rental voucher. And so in most cases, it's may not be all, but it's going to be most of the rental amount. It's rare for it to be a small percentage.
Okay, so, but in any event, there frequently is, you talked about the delta between the voucher amount and the rent. So there is a gap.
There can be a gap, that's correct.
Which would have to be filled by the tenant.
That's correct.
And then it's also true, is it not, that tenants frequently are expected to pay their own utilities?
So there's a utility allowance that's built into the voucher program. And so that the way that the program typically works, now there's a lot of vouchers. So there's veterans vouchers, there's disability vouchers. So, you know, I can't tell you I know all of them, but the way that typically works is that there's a utility allowance that affects the tenant's portion. So that if, let's assume just hypothetically that I make $1,000, I make $900 a month, and my rent is $900. So I'll pay 1/3 of my rent to the, my portion of the rent would be $300. The voucher program will pay $600. If my utilities are $100, I'll get an allowance. So the voucher program will pay more of the rent. It'll be charged against my portion of the voucher. So I'll still pay my 1/3, but some of that will go to utilities, some of that will go to the rent.
Answer me this, suppose what has just happened to so many Maryland homeowners and renters in the last 2 months happens, and the utility bill quadruples.
Yep.
And goes from $100 to, say, $600. How does that reflected in the voucher? Does the voucher now increase to cover the additional?
Yes.
Automatically?
So you report that to the voucher program. The tenants have got to report changes in income and expenses to the voucher program, and then they adjust the voucher.
Okay, this is all very interesting. But in any event, there is a gap. You referred to the delta between what the voucher is covering in terms of rent, utilities, I suspect insurance, required insurance, and that sort of thing on the one hand, and the total cost of all those elements on the other. Don't you think it would be relevant for a landlord to be able to check the credit history to see whether or not the prospective tenant would be able to meet all those extra expenses that are not covered by the voucher?
So, two things. The short answer is yes. I think that the landlord has an interest in knowing whether the tenant can and will be paying their portion of the rental costs. That's not in dispute here.
Does the bill permit that?
I'm sorry?
And does the bill permit that, as I
read? No, it does. What it doesn't allow you to do is use a credit score as the mechanism to do that, because there are other reasonable ways to know that, not the least of which that when you get your voucher, your portion of the rent is determined by your income. And so the landlord already knows, if they're accepting a voucher, the landlord already knows that the person has income sufficient that only 1/3 of their income is going to their rental obligation. So the landlord already knows that income exists because that is information that they've gotten from the housing authority.
But according to the bill, as I read the language in the middle of page 2, if the tenant, if part of the rent is going to be paid with the assistance of an income-based housing subsidy, then the landlord is not permitted to consult the tenant's income, credit score, lack of credit score, or adverse credit history.
Correct. Right. The credit score is not the only way you can understand whether or not someone is able to pay their rent. You look at what income they have. You look at whether they've been evicted in the past.
But this says income. It says the landlord is not permitted to refuse to rent on the basis of the tenant's income, credit score, lack of credit score. So all these things are ruled out.
Right, because you already know the person has income. Under the voucher program, you know that the person's income is going to be no less than three. Sorry. You know that.
Can I just say something? So can you just take a step back?
Yes.
And for the voucher, to get a voucher, what is that process to qualify for in terms of your income? Because the income that determination is made before the voucher process. That just, if you could kind of, I don't think we understand that. So just can you explain that?
Right. So the voucher program is set up so that the tenant will not be what they call rent burdened. So that more than 30% of your rent, 30% of your income is used for your rental portion, and the housing authority pays the rest. So the landlord already knows that
Is that a flat deal across the board?
Yes.
It's always 30%.
I don't know for every, I'm talking about the federal voucher program, which is the largest of the voucher programs. So
and it's
there are
30%.
a whole range of there may be other ranges, but yes, that is so a portion of the tenant's rent is.
So if you get a voucher for $300, the landlord can assume that your income is $1,000.
Correct.
Okay.
Correct. And if I were, let's say I had a job that brought me in $1,000 a month, and I lost that job, then the voucher then floats up to pay.
Okay, so now we've established, I think, that the landlord ought to be able to figure out what the tenant's income is based on the amount of the voucher. But this bill says the landlord may not refuse to rent on the basis of the income. So now the landlord knows what the income is. But if the landlord doesn't think that income's enough for the tenant to pay all the other expenses that are not being covered by the voucher, the landlord nonetheless may not refuse to rent to that tenant on the basis of the tenant's income. Isn't that what the bill says?
Correct. Yes.
Why does that make sense?
It makes sense because the voucher program is determined that the tenant already has sufficient income to pay the tenant portion. That's been done already by the voucher program. And then the voucher program is picking up the rest of the rent. So the landlord, when somebody presents the voucher program has already said, you've got enough income to pay your portion of the rent, and then we're going to pay the rest.
So the landlord has, under this bill, has to assume that if a tenant has a voucher, the government has done the vetting, the landlord doesn't have to do any vetting, and the government has concluded that the tenant can afford to pay whatever the rent is for that particular unit, plus utilities, plus whatever other incidentals.
Yes.
And so it's the government's determination, and you're saying the landlord should ignore those factors.
Yes.
Okay, thanks.
Yes. And I can tell you, people who have applied for vouchers can tell you that it's a pretty rigorous vetting from the voucher programs.
Just a couple, thank you. Just a couple follow-ups. Could you share later the rigorous standards you just mentioned for vetting? Two, you got that first request.
Yes.
Okay. Second, you mentioned a case that you thought was going to decide, I thought it was income, looking at income, but I'm not sure. You mentioned a case is pending. What is that case? Is that in Maryland?
Sure. It's Hare versus, and I forget the defendant's name. In that case, a landlord refused to rent to a voucher holder unless the voucher holder could establish that they had 2.5 times the total rent, not just the tenant's portion. Whether or not that's a violation of the Home Act is the question before the Maryland Supreme Court.
All right, very good. So could you send me that citation? Do you have a sense of, is that going to be, has it been argued and we're just waiting?
No, it's going to be argued, I think, in the May sitting.
And again, just put it in writing, but the chairman has asked, and I think Senator West has asked, and I'm still very unclear that if you were to exclude credit companies' efforts and collection of data, which is, I think, why landlords go to it, because I'm going to tell you, I'm a really mom and pop landlord. I don't know and or have the time to go around and try to find or replace the data that is often found in credit reports. But you can put this in writing. I'm trying to figure out where the information is that landlords can use. You make reference that the landlord can figure all this out from other sources, at least what you think is appropriate information for the landlord. So maybe you could articulate in writing what factors you do think the landlord's entitled to know, where that information is kept, whether it is collected so that a landlord could go to one source, or if the landlord has to go to multiple sources, and I'll figure out the rest, but that would be very helpful.
So I think that in the back and forth, I may well be not as clear as I'd like to be. And maybe that's an effort at over-precision here.
No.
But I think that the problem that this bill is trying to address is not really the issue about whether landlords are legitimately trying to figure out whether tenants can pay their portion of their rent. It is whether or not this is an artifice that's being used by landlords to exclude all voucher holders. And that is what we're seeing when you set a high bar and you heard stories about people who could not place a voucher, where landlords have said, we're just going to set a credit score that no one who uses a voucher can ever meet. And that's going to be our way around the Home Act. That's what this bill is trying to address. And that's the systemic problem
that is a good way
that's happening. That's the systemic problem that's happening in our community. It is not someone saying, you know, for the $100 difference between what the voucher pays and what can this tenant really pay that $100? That's not what's going on. What's going on is that landlords have figured out, I don't have to take vouchers if I just say you need to have a 750 credit score.
So what I'm worried about, I appreciate that, and I'm, you know, every time we do something, there's some that try to get around it. There's plenty of landlords, I think several are in this room, who don't think that, you know, bad actors should create laws that cover all of us. I like to really create a solution as narrowly drawn to the problem. And what I'm really troubled with is asking en masse all people that ever are going to rent to not have access or rely on information. I just think information gathering, I feel like you're almost censoring somebody, and people have a right to do research. So that's just my philosophical thing. But again, I hear what the problem is, and if you could still, nonetheless, provide in writing what the information is you think a landlord, I mean, in your opinion, what a landlord should look at or is allowed to look at, and how they would get that information other than a credit. But I also really want to understand this idea that if you have data, I really like to understand it, that landlords are en masse doing what you're claiming, and that everybody with a subsidy in Maryland is unhoused right now. So, you know, I want to just narrowly understand the problem, and I'd like to create a solution that is as narrowly drawn, because sometimes, as the chairman mentioned, we have unintended consequences. And what I'm worried about is losing more landlords, especially mom and pop landlords, sometimes who are better landlords, because we know the people, because we just keep creating barriers for the landlords, almost as if all landlords are bad, all tenants are good, and all landlord activities are suspect. I just have a problem with that. But that's not a question. So if you, you can answer the questions later after the hearing, that'll be fine.
I understand.
You know what I'm saying?
Yeah, no, I understand. I think this is a very narrowly tailored solution, because when someone has a voucher, they know two things. They know that the housing, whoever's paying the voucher is going to pay their portion of the rent. They know that whoever has the voucher has already determined that the tenant can pay the tenant portion of the rent. So that determination has already been made. So this is a very narrowly tailored solution.
Can the landlord get all the information that was made available?
They're not going to get the application for the voucher,
But see, I think, if you're going to exclude one area and then you say trust us on the other, no offense, but I feel like that's a paternalistic thing, just trust us. I think at least we should have the opportunity for the landlord to look at the information that HUD used and determine this. Maybe HUD makes mistakes. I don't know if that's possible, but it could be.
Yeah. Well, HUD doesn't make the determination. It goes to the local housing authority.
You know what I mean.
Yeah, yeah.
Well,
So
whoever's doing it, please.
In case I misled you, I wanted to be
No,
sure.
okay, all right, so you can follow up. Thank you.
Thank you, Mr. Chairman. Thank you for spending so much time with us and providing expertise.
I think the prior panel is regretting that they didn't have me up here originally because
you've been on the hot seat for a long time.
There's some real experts on the prior panel. So
well, this is good. So I want to follow up on a couple things that the chairman mentioned and then reference a couple questions. So I'm hearing the same thing as the chairman in terms of kind of the accumulation of well-intentioned bills that have unintended consequences. So on the 1 month deposit bill that just became law, if you think about what's happening in the marketplace, you have people coming off their leases who put down 2 months, and so they're getting back 2 months. And in a competitive market, you have people who are offering 2 months, even though only 1 month is required. And if you're a housing provider, you'd rather have 2 months. So I represent the district with the second largest Hispanic population in Maryland. And that population is getting crushed by the law we passed, which I was proud to vote for, because as they're competing and other people are getting their 2 months back, those people are offering up their 2 months, essentially like a down payment, like you see in the ownership market, to compete in the rental market. And the people who are most vulnerable are getting hurt. So anyway, just all of that is anecdotal, but just to kind of buttress what the chairman said. My question is about your proposed solution. In other words, if the credit score is not the most reasonable commercial measurement, it seemed like your solution was that we should, or that housing providers should use past rental history, evictions, failures to pay, and judicial records that reflect that person's willingness and ability to pay their obligations. Was that your testimony earlier?
So simply, having been in the housing world for a long time, I was at Legal Aid, I was at the Public Justice Center, so I've been working with tenants a long time. I actually think that once someone has a housing voucher, the inquiry about whether they can or can't pay their rent should end there. There's no other inquiry. There are legitimate inquiries that a landlord might want to make about whether or not someone had destroyed their prior apartment, whether they had been charged with a crime in their prior apartment, whether or not there's a record of some sort of disturbance with the neighbors in their prior apartment. But the question about whether they can pay their rent, once they have the voucher, that should end. There really is no other
so you're
thing
saying
that
if
the
someone
landlord
has previously been evicted, that under this bill,
if they're previously evicted for the fact that they violated the terms of the lease, that they destroyed the prior property, that kind of thing.
and how would we know that?
Well, there are services that you can go to that will look at all of the eviction records across the state of Maryland.
So you may not recall, but I'm pretty sure last year we provided for the expungement of eviction records, which I think your office supported and we voted for. In other words, your proposed solution as an alternative to this bill is now off the table because of a previous bill that your office supported.
No, those are apples and oranges, I think, in this regard. If what the landlord is trying to determine is, can this person pay their rent? The fact that they have a voucher answers that question, right? That should be the end of the inquiry. There's nothing more the landlord really can or should want to know, because they know the two most important things. They know that the housing authority is going to pay their portion of the rent, and they know the person's been screened by the housing authority and knows that the person can pay the portion of the rent that's the tenant portion of the rent. So we know the landlord is, when somebody walks with a housing voucher, landlord knows, okay, I know those two things. I know that the tenant has enough income to pay the tenant portion and that the housing authority is going to pay their portion. There may be all kinds of other reasons why you might not want a particular tenant if they've had historic problems being a tenant unrelated to their ability to pay the rent. But with the voucher, their ability to pay the rent, that is a question that is essentially resolved.
Right, but
with
if
the
we
voucher.
eliminated the ability of landlords to access that information because we provide for a 3-year expungement of all eviction data, then they no longer have access to the very data for which you are asking them to rely.
Right.
Let me ask you about job loss. So you indicated about job loss. I apologize. These new mics work differently than the old mics. About job loss. So you're indicating someone is covering 70%, the other 30% is their responsibility.
Right.
Now, just to go back to the previous conversation, someone could be evicted for not paying their own 30%.
Correct.
In previous. But you said if there was a job loss, the voucher would then shoot up to 100%.
Mm-hmm.
What is the time period between the job loss and the increase in the voucher? Is that days? Is it weeks?
So
Is it
it
months?
should happen virtually simultaneously if the tenant reports it. There may be some challenge if the tenant fails to report, and then there could be a period of time it takes to adjust the voucher.
And do they get back pay?
You know, I don't know the answer to that question.
In other words, you could have a situation where a provider, where someone loses their job, is unable to pay their portion of the rent because of some bureaucratic error or because the person may not, you indicated some people in this situation have disabilities. They may not have the capacity to navigate the bureaucracy necessary to report the job loss. You could have a circumstance in which someone with a voucher is unable to pay their 30% for months until either they or the government processes the new voucher amount. And it sounded like the new voucher amount does not account for the missed months. In other words, you don't get back pay.
Yeah. I don't know whether it addresses the back, but what I don't think that circumstance won't be addressed at all by whether you check someone's credit in advance or not. Any event that happens after someone's a tenant, you're not going to be able to identify that as a potential issue by doing a credit history before the person moves in.
Well, you might be able to identify it if that person was previously evicted and on a voucher, in other words, not paying the 30%, but that's expungible under our current law. And secondly, you may be able to understand that based on previous income history. In other words, if someone is frequently gaining and losing, then that person may have current income, but their history may show that that income is less stable than other people, including other people on vouchers.
Sure.
Okay. Thank you.
Sure.
Thank you, Mr. Chair. Thank you for sitting in the hot seat. So, look, I agree that we have a housing shortage, and we need to find more landlords who are willing to jump into the pool and provide this service. So, if I was a prospective person thinking about buying a property and becoming a landlord, how does the passage of this bill encourage me to be a landlord?
I don't know that it should encourage or discourage. I agree with you. The primary problem we have is that there's a shortage of affordable housing in this state and across the country. But there's also a very primary problem that's related to that of housing segregation and sort of a legacy of housing segregation. And one of the reasons we have a voucher program comes out of a recognition in the 1980s by HUD and other places that site-based housing, supported housing, federally funded housing, was increasing racial segregation rather than decreasing. And the voucher program was designed to allow people to move into opportunity neighborhoods of their choice. And that, in the state of Maryland, that promise has proven elusive in part because of discrimination against people who hold and use vouchers to pay their rent. And so what this bill would do is to help both make it easier for people who have a voucher to actually obtain the voucher, but also to eliminate or reduce the discriminatory effect or the racially discriminatory effect of using a high credit score to prevent someone from being able to place their voucher. So I don't know that if I was going to enter the rental market, I know that there's anti-discrimination provisions. I can't discriminate against someone who uses a voucher. I don't know that this bill changes my calculus about whether or not I think I can make a profit as a landlord or not. I could tell you that there are lots of places, and I'm most familiar with the District of Columbia, where I practiced law for a long time, where this is the law in the District of Columbia, and there's a very vibrant rental market, and landlords are making a lot of money.
So when you talk about the vibrant market of the District of Columbia, hasn't there been a revitalization of the District of Columbia? I think I saw reports where low-income people are being pushed out of D.C. because they can't afford the rental market. Does that have anything to do with your statement of it being a vibrant place for renters to rent, but is that data driven down for low income?
So it's a mix. There's a very interesting conversation and a very interesting set of problems. One of the ways in which the Housing Authority in the District of Columbia has addressed that is to raise the rent standard so that people can move into opportunity neighborhoods. And they're placing vouchers throughout the city. So there's neighborhoods that have historically been very high income. There's been a push to move voucher holders into those neighborhoods to provide opportunity to those families. And that has been, in some places, a very successful program. There's been some mixed results as well, largely because of the lack of support for people when they were moved for new tenants when they moved into those neighborhoods. So it is true that there's a lack of affordable housing in the District of Columbia. It is true that there's been a loss of low-income, and particularly low-income African-American families from the District of Columbia, but there still is a very, very large low-income rental market.
Okay. And just last, Mr. Chairman, so this bill really doesn't address the encouragement of the housing shortage to solve it?
It does not encourage or discourage. I think it addresses one part of the problem that was trying to be addressed by the Home Act. It corrects what was essentially a gap that was created in the Home Act, and it closes that gap so the Home Act can have the meaning that it was intended to have.
And in layman's terms, I'm not exactly sure that helps solve the housing crisis, but I'll ask the next panel that same question. But thank you, sir.
Okay. Thank you very much.
All right. Seeing no further questions, thank you very much. That was a long one, so I appreciate it.
Thank you, sir.
Welcome to JPR, you know. You earn every inch in this committee. All right. With that, that'll end the testimony for the proponents of the bill. We'll now switch to the opposition, and we'll now hear from Aaron Greenfield, William Castelli, and Brian Anlou.
Mr. Chair, Liz Kruger, she was signed up favorable. She was locally. She's here now. I'm wondering if there's a possibility.
Okay, I thought Mr. Hill, did you fill in for her?
No.
Mr. Turner, okay, got it. Yeah, is she in the, where is she?
Here.
Oh, okay, hey, how are you?
I appreciate it.
Well, come on up and then we'll switch to the opposition panel.
And apologies on being late.
I'm just impressed you want to get up here now after that round. So there you go. Let's go.
That was brutal, but I feel like since I'm at the end, it won't be as bad. So
welcome.
Yes, thank you. And good afternoon, Chair, Vice Chair, and committee members. Thank you so much for the opportunity to provide testimony concerning an important priority for Interfaith Works, which is a nonprofit based in Montgomery County, providing essential needs, employment services, shelter, and supportive housing. And we also this month are actually extending our services into Prince George's, which we are very excited about. So, IW strongly urges the passage of Senate Bill 677 because we know it is a necessary measure to help Maryland families move out of crisis and into stable housing. At IW, credit scores remain the largest barrier our prospective tenants face to housing. While we understand that credit reports and scores are a typical part of housing applications, the same assessment of past financial decisions prior to receipt of a voucher should not be applied. We consider that discriminatory. Furthermore, national data, including social science research from Harvard, sorry, I need glasses, that finds that the most significant predictors of future non-payment of rent are not past financial struggles, but instead the current stability of one's income and, in fact, the number of children in a household. Sudden job loss and unstable childcare are far bigger threats to one's ability to pay rent than even a past eviction. This national data is certainly consistent with our numbers at IW. Of the 310 individuals and families we have served in our supportive housing programs in the past 2 years, less than 5% had problems paying their portion of the rent, which is significantly less than the national average of all renters posted in 2024 by the Government Accountability Office. For this reason, IW asks for your full support in passing this bill and a favorable report to protect the Maryland individuals and families made vulnerable by poverty.
Excellent. Thank you very much. It was worth the wait. It's good to see you. Thanks.
Yeah,
Thank
good
you.
to see you too.
All right. Seeing no questions, thank you very much. All right. With that, that'll conclude the testimony for the proponents. We'll now switch to the opposition panel and Mr. Greenfield, Mr. Castelli, and Mr. Anliu. Who else has signed up? I believe that's it.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. Aaron Greenfield on behalf of the Maryland Multi-Housing Association, and we're in opposition to this bill. You have our written testimony. As Senator West kind of gathered, a housing provider will still need to screen for income, even if a resident receives a housing subsidy for several reasons. One primary concern is the ability to cover the non-subsidized portion of the rent. Housing subsidies typically only cover a portion of the total rent, leaving the resident responsible for the payment of the remainder, as you heard before. A housing provider needs to ensure that the resident has sufficient income to meet this obligation. Beyond rent, residents must also afford other housing-related costs, such as utilities, renter's insurance, if applicable. Screening for income helps verify financial stability and ensures that tenants can handle these additional expenses. I want to mention, the proponents spoke of the public housing authorities doing exhaustive screening. Well, that information isn't shared with us. We don't have that information. We can't verify that the resident can actually afford the additional 30%. So that information just isn't provided to us. So it's sort of a wish and that the public housing authority has verified them and that they can afford their 30% of the rent. Housing providers play a critical role in ensuring that residents can afford their housing costs. They have a fiduciary responsibility to ensure that prospective residents can afford their portion of the rent along with those utilities. This is not a business imperative, but also a necessary step. This is not only a business imperative, but also a necessary step to prevent evictions and the associated social and economic costs associated with those. By precluding housing providers from screening residents based on their income, credit score, credit history, this bill will undermine the critical process. For these reasons and many others, we respectfully request an unfavorable report on House Bill 896.
Good afternoon, Mr. Chair, Mr. Vice Chair, Brian Anliu with the Apartment and Office Building Association of Metropolitan Washington. Mr. Greenfield and others have made a lot of the points that we've made, so I won't repeat them. I would just simply say that we think that income and credit scores are a fair and objective way to screen tenants, and I think the suggestion that you look at past rental history actually has the opportunity to inject more bias and discrimination into the process. If you're having a property manager call to past landlords to look at whether that tenant was a good tenant or not, whether they paid on time. We think in the case of credit history, it's just that. It denotes your ability to pay your bills on time. So we think that that's fair and objective, and we'd like to retain the ability to do that. For those reasons, we urge an unfavorable report. Thank you.
Mr. Chair, members of the committee, Bill Castelli on behalf of the Maryland Realtors. We have many property managers that manage a lot of single-family properties, rentals. And we have some of the same concerns that the previous panel spoke about, or the previous panel here spoke about. But the job of a property manager, too, is not just finding a tenant, but they are required to find the best tenant. And I can assure you, credit score is just one of the pieces of information that they look at. And the more information that you restrict from a landlord being able to, or a property manager being able to review and determine whether this person is going to have success in that property for a long time, because that's what the landlord wants. The landlord wants that person to be there as long as possible, and the tenant wants to be there as long as possible. And one of the ways the landlord can help assure that is by looking at all this information to make sure that they have the financial ability to be there and be successful in that property. So this helps them find that best person. So for that reason, we think we would request an unfavorable report.
Thank you, Mr. Chairman. This question is for Mr. Greenfield. So I'm acknowledging we've got a housing shortage, and I want to get into the multi-housing business, and I'm very well off. I've done well doing something else, and I want to invest in a multi-housing. My question is, will the passage of this bill help me find others to help finance this project? Will this help me get the return of investment on trying to solve the housing shortage? How will this help me find these people, or would you believe that this would not help me?
Yeah, I don't think this is particularly helpful. If you take this in combination with the other things that have been passed, and probably the good cause, which is likely to pass, what you're going to see is an increase in qualifying standards and criteria across the board. So what you're going to find is that landlords are going to now increase their qualifying criteria across the board for fair housing purposes. They're going to heighten those criteria. So it's going to be harder for applicants, prospective residents to qualify for housing, which could in fact make it harder for your investment.
Okay, thank you. Mr. Chair, one more. Thank you. This is for Mr. Castelli. You had mentioned about representing single-family homes and those type of stuff. If being a realtor and saying you want to give some advice to somebody who may want to help solve the housing shortage, what would be your advice to them getting the information that they want to get to make a decision? But if the passage of this bill restricts that, do you think you would have more people getting into the housing shortage, or do you think that this bill would hurt that?
I would say, and that conversation is had. I mean, you have a lot of reasons why single family, a person with a single family home may be returning to the home. So they do have these long conversations about whether they even want to become a landlord now, because it is a serious process that they need to consider and pay attention to, and it costs money, even if they're, making a little money on the side from the rent. So anything that makes it more difficult for them to assess the viability of tenants that they're coming, the more complicated it is, the less control that they have over the property, makes it less likely that they're going to want to do that.
Okay. Thank you, sir.
Thank you, Mr. Chair. Mr. Greenfield, could I ask you just maybe two questions? First of all, you heard my dialogue with Mr. Smith from the Attorney General's office. He seems to feel that the landlords should be comfortable letting government do the vetting of proposed tenants, and the landlords should be comfortable with a statute which says they're not permitted to do the same vetting. What is your reaction to that?
Yeah, I respectfully disagree with that approach. I think the reality is, as I said in my testimony, housing providers have a fiduciary responsibility. It's their investment. They're trying to lease it for someone else's home. And I think they should have the responsibility and the ability to vet the prospective resident. And as I said earlier, it's not as if we get the verification data from the Public Housing Authority. that shows that the person is qualified. So that information is not supplied to us.
So you're being asked basically just to take it on faith, that since the Public Housing Authority theoretically has done the vetting, that should be okay.
That's exactly right. That's what this bill is more than suggesting.
And then secondly, returning to Senator McKay's conversation, I remember during a briefing we had at the beginning of this session, you standing and reciting to us a long list of bills that we've passed in recent years, which are pro-tenant, where the flip side of that coin is anti-landlord, and suggesting to us that the cumulative effect of all these bills is to discourage the construction of rental housing in Maryland. Do you think this bill would simply be yet another check the box item on such a long list, or would this bill have little effect on the interest of people in investing in rental real estate?
No, I think as the chairman alluded to earlier, this is a cause and effect. And I think this would be another check on that list, along with good cause, if that passes. Again, screening criteria will be heightened going forward for all residents, which will make it harder for folks to find housing.
Thank you.
I've often said that Senator West uses that list that we've passed as a sword. I use it as an aegis, but but the discussion continues. So, what question about just the credit score? So, it was. I think someone mentioned that the average credit score for a voucher holder was somewhere. Was it 5 something? Can someone 5 something? So, what do we learn? If you're using the credit score, you know if the person has a voucher. You know that their credit score is probably in this ballpark of credit score. And I guess my question then is, then what utility is it anyway? If you know the person, if those two things are linked, then why do you care? Because you know the profile basically.
Yeah, I mean, I wouldn't, Mr. Chair, if I may, I wouldn't suggest that every voucher holder. I mean, I hear that the average one may have a low credit score, but there's certainly some that have substantially higher credit scores that may qualify them. And so for us, I think it's an indicator, because you don't want to have to call previous landlords and determine what is their rental payment history. And as the vice chair alluded to, you can't look at eviction records. So how else do you determine their ability to pay their bills on time, if not through a metric that essentially does look at that and whether they're able to or not?
All right, thank you very much. Further questions? No further questions. Thank you all very much. Thanks. And with that, that'll conclude the hearing for Senate Bill 677, an hour and 38 minutes into the day. All right, we'll now move on to our second bill, Senator Muse with Senate Bill 651.
Panel can come up if we have one. Thank you very much, Mr. Chairman, Vice Chairman, and I promise this testimony will not be nearly as long as the last testimony, which I should have known when I looked up and saw that everybody was gone except Senator Wallstreicher, and he was on his phone and having lunch. So I knew that I should have known I had gone long on that testimony. I won't do that. I won't do that today. Thank you very much. For the record, I'm Senator C. Anthony Muse, representing the 26th Legislative District of Prince George's County. My panelists have joined me, and others may be coming. Zafar Shah from Maryland Legal Aid and Chuck Cook from the Department of Housing and Community Development. At the same time, many of my friends came down, and many friends of this bill who thought it was so important that they came, they stood outside, rallied, so that people will know it's important to them. And I'd like to ask all of them to stand. You'll hear those who support this bill. Please stand and thank, and we thank them, don't we, for coming down and doing this today. Thank you. We can all agree on the basic principle that every Marylander, whether a homeowner or a renter, deserves the stability in their community, regardless of race, class, or zip code. And this is really the intent of SB 651. We often hear about the urgent need for more affordable housing. What we don't hear enough about is how to keep people in their homes. How do we ensure that children stay in the same schools? How do we help seniors remain near their doctors or public transportation? How do we make sure essential workers can continue to live near their job? So let me start by saying what this bill does. SB 651 is local enabling, it's enabling legislation, nothing more or less. It does not impose a statewide mandate. It simply allows counties to pass good cause eviction laws if they choose to. If a county does not want to pass such legislation, they don't have to. But if they do, this bill ensures that at least they have the power to act. 41 county officials have asked for this tool, including my own Prince George's County. Yet Maryland remains one of the only 5 states that prohibit counties from implementing good cause eviction protections. 8 states, including Colorado, New York, and 23 counties and cities nationwide, have already passed similar laws. So the question is, should we be, or why are we blocking local governments from making their own housing decisions? We don't want to impose this on everyone, but at the same time, if a county wants to do it, they should not object to it. So the bill requires, at its core, the bill simply says a landlord must provide a legitimate reason for evicting a tenant. This is not radical, it's just common sense. Each year in Maryland, over 5,000 tenants are evicted without being given any reason at all. Also, when it comes to addressing landlord concerns, small landlords are exempt. If you own 5 or fewer properties in Maryland, this does not apply to you. The bill prevents corporate landlords from hiding behind multiple LLCs to avoid accountability. It does not change the non-legitimate reasons for eviction that were already established in last year's version of the bill. Doesn't change at all. Who is most affected by no-cause evictions? First of all, families, forced to uproot their lives, disrupting jobs, schools, and support networks. Number 2, Black and brown children due to systemic inequities. 1 in 4 of our Black children in renting households faces a threat of eviction every year. Third is entire neighborhoods. When tenants fear eviction for reporting hazardous conditions, properties fall into disrepair, lowering property values for everyone. So the bottom line is this. This bill costs the state nothing, yet it protects thousands of Maryland families from unfair evictions. In other states and counties across the country, if they can do it, then Maryland should not be left behind. This issue is personal to me. I lived in 11 foster homes, and all I did, I moved from county to county and place to place, and growing up, leaving friends, leaving new schools, on and on. So I know what it feels like. And no one should be put out of their home without being given a reasonable, legitimate reason, rather. I'll close with this. After many years of delay, the House passed this bill last session. Now, my friends, it's time for the Senate to act. Therefore, I respectfully urge a favorable report on SB 651. Thank you all for listening. And
Chairman, Vice Chair, members of the committee, thank you. Sponsor, thank you very much. For the record, Chuck Cook, Chief Legislative Officer for the Department of Housing and Community Development, here to speak on support of SB 651. So this enabling legislation allows local jurisdictions to enact local legislation requiring landlords to renew a tenancy absent good cause, and a list of the reasons for good cause eviction are enumerated within the bill directly. The administration is focused on increasing housing production and increasing housing stability. It's what 2 of the governor's 3 housing bills last year aimed to do. With the Housing Expansion and Affordability Act, the General Assembly made steps to increase production, and with the Renters' Rights and Stabilization Act, you voted to increase housing stability. Giving Maryland counties the authority to enact such provisions will increase housing stability across the state while not negatively impacting housing production. Encouraging long-term tenancy benefits both renters and communities by slowing displacement and gentrification, maintaining neighborhood stability, and preventing the material hardship of being forced to find new housing, which is particularly disruptive for mothers and young children. New tenant protections enacted under the law will only be implemented through the democratic process at the county level, and it will reflect the diversity of Maryland's housing market across jurisdictions. Finally, we can provide greater housing stability with this legislation with, as the sponsor noted, without negatively impacting our state budget. This is a no cost to the taxpayers way to provide more housing stability when budgets are tight. And so for this reason, the Department of Housing and Community Development respectfully requests a favorable report on SB 651.
Just for the PSA, we generally, just if the audience, this is not a audience participation sport. I know everyone's enthusiastic, but if we could please keep the proceedings in order. Thank you.
All right, thank you, Chair Smith, Vice Chair Wellstreicher, members of the committee. Once again, for the record, Zephyr Shaw from Maryland Legal Aid, and we are a member of the Renters United Maryland Coalition. And much of what I wanted to say has been said, but I will also just point out to the committee that this is the 14th year since 2008 that some form of good cause eviction has come before the General Assembly. The state went from the 2008 housing crash and continued straight through COVID-19 and into what is inarguably another housing crisis currently, never changing the fact that renters in Maryland are exposed to the daily threat of arbitrary lease non-renewal for no cause. And opponents want you to believe, or perhaps you already believe, that it's good cause eviction, tenant protections, rent stabilization, these issues that have caused a housing crisis. But I ask you to think of anyone that ever told you over these many years that developers were promising to come to Maryland to build affordable rental housing because it was so easy to evict renters here all this time. Since 2008, with Maryland continuing to do nothing on this issue, Colorado, California, Oregon, Washington, New York, and New Hampshire have enacted state good cause laws. New Jersey and Connecticut already had these protections dating back over 40 years, and Philadelphia and DC have these protections. This bill is not about rent control. It's not about vacancy control. It's not about anti-development. It's about preventing displacement. As you plan to increase housing production in this state, you need to keep your constituents in your districts, in their communities. That's what's fair. And we urge a favorable report on SB 651.
Thank you very much.
Mr. Chair, this is for the sponsor. Senator? So in the opposition, the Maryland Judiciary opposes for the simple reason that the district court is a statewide court system designed to provide uniform application to law for all who come before it. We know that this is enabling for the locals, but what they're telling us is they're in opposition because where this would be decided is in the district court, and that would be a statewide. I did not know this was in for 14 years in some kind of version or whatever. Right. But my question is, has that ever been addressed?
We've heard that before, and when we've given answers, they simply do not respond. We've said to them over and over again what this is. It's enabling. They've given their side 2 or 3 times down through these 14 years, and we've tried to respond as best we could, but then there's no response to the response.
Okay. The second question that I have, if I may, Mr. Chair, has to do with just contracts. Mm-hmm. Is there other places in the Maryland Code that when a contract ends, one side gets to extend it and not give, and it is forced, to, if it is going to end, to give a reason?
I'm not sure. Let me see.
I mean, does a cable company?
We don't believe so, but, okay, yes.
If I could, Senator McKay. So, you know, in labor law, which we do recognize in the state of Maryland, we have contracts which require cause to terminate. We know in insurance, for instance.
Do we, I thought Maryland was an at-will state.
If it's a negotiated, collectively bargained labor contract.
Okay, but how much does that make up in the state of Maryland?
I couldn't tell you that.
Yeah, I don't know either, but Maryland is an at-will state, correct?
I believe it is.
Okay,
but
thank you. I'm sorry, I interrupted, I apologize.
I'll just point out briefly to Senator that although our insurance laws don't require good cause for termination of insurance policy, they require your insured to provide a reason. And that's something that we don't require for lease non-renewals. We don't require any reason at all, that's what makes it so easy to use this process of lease termination and eviction.
So from an insurance standpoint, so when I get that they've just chosen not to offer me a renewal, they have to give me a reason?
They do. They have to provide a reason. It doesn't have to be a statutorily enumerated reason, but then that you as the consumer can then appeal that reason.
So the reason can be that they just don't want to continue, or that they're not offering that in the state anymore?
I'm not an expert on that, Senator, but we could look into it if you'd like to.
If anybody else has any other contracts that we would follow, I'd be interested to find out that data. Thank you, sir.
Thank you, Mr. Chair. So let me ask some questions of the sponsor of the bill, Senator Muse. So I'm reading the bill, and on page 3, it says the tenant must be provided with the full legal name of each individual and the business name of each entity with direct or indirect ownership in the residential rental unit. Why would you need to know the names of entities or individuals with indirect ownership? If there's a problem, it would be the landlord that would be subject to discipline. Isn't that correct? So why do you need to know to go through the chain of ownership all the way up the line and find out every individual up the line who has an indirect ownership interest?
Which one then will do that? Let me get someone who can give you a better answer than I can and make it shorter than I will.
Short is helpful.
Yeah, thank you, Senator West. It's a good question because that portion on page 3 is about the disclosure requirements for an owning entity that invokes the small landlord exemption in the bill. So it's not a disclosure of, the chains of, or the identities of the different people or entities within an ownership structure in terms of whether they are compliant with good cause. It's simply transparency about whether the entity that claims to be a small landlord under this bill, so that they're exempt from the bill, is actually what they say they are. So when we talk about disguised owners who, for instance, might have a single asset LLC, but the people behind that LLC own many more than 5 units, this bill is requiring them to actually put it on paper, both at the time of the lease, at the time of lease renewal, and as well as whenever they terminate the lease and seek to evict a person, invoking that they're not covered by good cause. They need to put it on paper and show what that ownership structure is, who in that ownership structure owns property, how many properties, and the locations of those properties.
But
so it's about transparency.
This would apply in every single situation, whether or not the particular landlord is making a claim that the landlord owns fewer than 5 units, right? This would be across the board. So every single landlord in the state would have to disclose the entire ownership structure all the way up the line, including everyone who has an indirect ownership interest.
Only if they're invoking the exemption from this bill.
Where is that? Where does it say only if they're invoking the exception? I don't see that in here. Maybe I've missed it.
So if we go to the bottom of page 2, line 32, so a landlord stating in a notice that the local good cause provisions do not apply to the landlord shall provide the tenant, and so on and so forth, with the information about how they qualify for the exemption.
But there are lots of good cause provisions which would not apply to the landlord, aren't there? I'm looking at pages 5 and 6, and I see, I get to 7 on page 6, 8, 9, 10. There are 10 of them in total.
There are 10.
Right. So again, it sounds to me as if this is a requirement that every landlord that invokes any one of these 10 provisions.
But the 10 provisions, the 10 good causes, apply to landlords that own 6 or more units. So they're not, if they're out in the open with the number of units that they own, then they're not going to have to provide a disclosure. So let's say it's one of MMHA's members, a very large, significant landlord. There's no question that they're going to be required to have a good cause in the counties that opt into this legislation.
Okay, I don't see that in the bill, but we could always amend the bill to clarify this. Secondly, second question, on page 3, it says an individual or entity has an interest in a residential unit if the individual entity has a direct or indirect ownership or membership interest in any entity. What about an entity that holds a mortgage or a deed of trust? Would that entity have to be disclosed?
Maybe you could fill me in a little bit more on what you're thinking about. An entity that is part of the ownership and owns the mortgage.
The bill says an individual or entity has an interest in a residential rental unit under subparagraph 3 if the entity has a direct or indirect ownership or membership interest in any entity that has a direct or indirect ownership or membership interest in the rental unit. So my question is the holder of a mortgage or a deed of trust on the property included in this list of organizations, entities that would have to be disclosed?
I don't think so.
Including the owners of that entity?
No, I believe the answer is no on that. We could make it more clear, certainly, but that's not the intention. That's not what the bill drafters were trying to accomplish there.
All right, and then last, maybe the sponsor of the bill can answer this, and that is the key language that I find in the bill is on the bottom of page 5. It says, subparagraph 2, a county may adopt by local law or ordinance provisions that prohibit a landlord from, quote, failing to renew a lease. So I'm interested in what constitutes failing to renew a lease. Let's assume a landlord currently in its leases has nothing relating to pets, and the landlord has decided that it wants no more pets in the building and wants to change its all future leases to prevent pets. Would that constitute failing to renew a lease because the lease is being altered to prohibit tenants from having pets in the building?
I don't think so, because the 10 provisions are outlined that these are good causes.
All right, let me go on to another one.
And if we need to make that even clearer, then we can do that with an amendment.
Suppose a landlord decides wants to alter its leases to prohibit the use of pot in its apartments because of complaints that the landlord's been receiving about smells. Would a landlord under this language from quote, failing to renew a lease, would the landlord be in violation of this if the landlord included in new leases a prohibition on the smoking of pot on premises?
First of all, I'm not sure, based on at least the laws that we've worked on, I'm not sure they can do that anyway. But if they could, if it doesn't fall, as far as I can tell, if it doesn't fall under those 10 guidelines, you have a problem.
Let's go to a more highly charged issue. changing the monthly rent to increase the rent. That, as I read it, is not included in the 12, is it 12? 12 or 13 of the exemptions. If a landlord wanted to alter the lease to provide for an higher amount of rent during the next term of the lease, would that constitute failing to renew a lease?
They can do that, and if you look at page 6 and beginning in line 1721, you'll see where that's not an issue.
I don't see anything here about rent. It says a holdover tenant failing to accept a landlord's offer of a new lease agreement for a term of at least 1 month, but not longer than the term of the lease agreement, effective immediately before the holdover tenancy within 1 month after the landlord makes the offer over a greater period of time as otherwise established by law. There's nothing about rent there.
If I may, Senator, there's no mention of rent because the bill doesn't countenance any restriction on rent increases.
All right, so let me just run down the list then. So if a landlord wants to offer a new lease, but the new lease is different from the old lease in the following respects: it changes the term of the lease, it changes requirements about pets, it changes requirements about smoking noxious devices that create fumes like cigarettes or pot, it adds provisions about noise, it changes the monthly rent, changes the amount of the security deposit, changes the payment terms, changes the utility requirements, changes the insurance regulations, and changes provisions about improvements that tenants can make to an existing apartment without previously securing landlord approval. All of that would be permitted under this law, if passed, correct?
I believe so. And I believe that does prove just how much of a compromise this bill is. Advocates have gone head over heels to accommodate legitimate business interests of the opponents of the bill. I think the list that you just provided is a testament to what landlords will be able to do and what tenants don't get out of this bill. They don't get everything that they want in the localities that may already wish to pass a stronger version of this would not be able to. They'd still be stuck with the 10 types of good cause under this bill.
Okay, and just to put the period at the end of the sentence, Senator Muse says the sponsor of the bill, you agree to what Mr. Shaw just said, correct?
From all that I've read, yes, and from presenting this bill before, yes.
And the reason I'm making a point of this is that we have something called legislative history.
Sure.
And this phrase, the renewal lease, is not really, it's not defined and it's not really clear. So in the event down the road, there should be a contest in court. The litigants will be able to refer to this interchange between me, Mr. Shaw, and you as constituting the legislative history of this bill. Thank you.
Thank you. Thank you very much for your question.
Thank you. Kind of off of what Senator West was talking about in the long list, if I just boil down the list of increasing the rent, if we pass this, have we created a new loophole that will just automatically increase rent on people?
No.
If I just don't want to rent to somebody for whatever reason,
and you increase the rent,
and to get around it all I'd say is, okay, it'll be another $500.
Again, I don't see where that affects it.
Well, it's true.
Okay. Yeah, it is true.
I think this question is very important because it speaks to the interconnectivity of all of these regulations across the state. And it's a little bit of what Senator West was talking about. And so in Montgomery County, for instance, we have some form of rent stabilization, and so Prince George's County also doing that. So he's absolutely right to ask this question because it shows you that nothing happens in isolation. And so my question then, I'm sorry, let me let you finish, but I just want to make sure. So
I yield to you, sir.
So I appreciate that. My question, Mr. Cook, I mean, your question. So look, you will, sometimes you'll get the right answers when you ask the right questions. You always get the wrong answers if you ask the wrong questions. And a lot of time, these questions need to be focused more on not just this policy, but also how these things are layered on top and how it all interacts with each other. 'Cause nothing happens in isolation. So I know you all are in support of this bill. What is your department, the secretary, the governor, what is your stance on rent stabilization?
Great question. So obviously, like I said earlier during the testimony, we were very supportive of good cause eviction for the simple fact that it provides a stability and does not sacrifice production. On rent stabilization and rent control, the administration has not taken a position. It's a complicated issue. We're always concerned about any impact that any policy could have on production, because it is our stated point that the best way to increase housing affordability in the state of Maryland is increased production. So as of right now, we have no position on that particular issue with rent stabilization and rent control.
And so, that's exactly. I mean, it's like these things serve as not necessarily a red light, but at least a bright yellow flashing light of caution, because as we talked about earlier, we have a massive housing shortage in Maryland. We have 100 jobs and only 33 workers to fill them. The pocket of workers, that workforce, that 18 to 34-year-old population is leaving, and the number one cited cost is 32. Is the number one cited cost is housing affordability. We learned that 53% of Marylanders are housing burdened, meaning they're paying more than a third of their monthly income on housing. So, I mean, you don't have to be an economist to understand that the supply and demand problem here, and you want people to obviously enter the marketplace to build affordable housing, that missing middle that we always talk about. And so that's why it's important to talk about the rent stabilization, because it is interconnected. Because like you said, Senator, if you don't have rent stabilization, then okay, you're right. You just jack up the rent, and that's not covered under this bill. But if you do have rent stabilization in your jurisdiction, then you will not be able to raise the rent, and that will not be a cause under this thing. And so these are just things you have to kick around in your head when you're thinking about this. And so I appreciate kind of a nod to understanding that there's a caution for all these things, because it's not, I like this, I like the notion of good cause, but we have a responsibility as a committee to be intellectually honest, to understand how those things fit into the regimes of other jurisdictions. So like when you have good cause and you have rent stabilization and you have vacancy control, just at least understanding how those things interact is very important to make an informed decision for this body. That's all I'm saying. So thank you for that. Senator McKay, I'll cede the rest of the time. I have a couple more questions, but sorry about that.
Mr. Chairman, my question is for Mr. Cook. You had made mention, and correct me if I'm wrong, you said it's the administration or the departments that the passage of this will increase the rental production?
I did not say that, no.
Okay, how did you say? What
I said was we have no position on rent stabilization and rent control, and that we are always paying attention to policies that could impact production.
Could impact production.
Could impact production.
Okay, my question is, do we have any data that shows in other states that have put good cause, you may not, but you guys may have, that has shown that the production of affordable housing or by passing this has actually increased the availability to housing? And you don't have to have the information now, but it would be interesting, good data for all right, thank you.
Just for Mr. Shaw, again, I want to give you an opportunity to address some of the things that are going to come up in the next panel. So for a lot of Senator McKay also talked about the contractual relationship and not understanding if there's any other area of law where you're kind of bound, just the general concepts and theories of contract law, where there's an offer, acceptance, consideration, meeting of the minds, and then the term of that contract ends, and then that's an invitation to re-engage and set forth and sally go on with another contract if there can be that meeting of the minds. In this condition, in this bill, but for these circumstances, obviously, there's no renegotiation. You got to, if you're in this business of providing housing and the tenant hasn't done anything under this, wrong, then you got to continue to offer that housing to that person. Got that. The question is, there's going to be a question about presumption. And whenever there's kind of an accusation of wrongdoing, the presumption is always on the movant. to prove. They have to overcome. And so this switches it a little bit, or does it? Because now the housing provider has to kind of overcome that presumption that they didn't do something wrong. There's no kind of presumption of innocence, for lack of a better term. I know this is a civil context, but can you just talk about that? Because that's going to come up. I wanted to give an opportunity to kind of address that presumption switch, or perceived presumption switch.
Great question. Thank you, Chair. I think that your characterization is correct. This is about changing the burden of proof from one party that has very little bargaining power, from them to the other side, which I don't believe. My opinion, having over 10 years practice in district court eviction cases, is that even in a breach of lease case where a landlord must prove what breach occurred and whether it was substantial and whether it warrants eviction, they're not held to a very high account in district court. We continue to see that even today. I think that what good cause eviction does is it brings that lower power party up closer to a level playing field in terms of how they negotiate for whatever, whether it's amenities, whether it's protections, whether it's just compliance with the contract, the lease agreement with the landlord. And I think that as we talk about what this housing crisis looks like in terms of housing cost burdens, but then also just the lack of opportunity both to purchase a home and lack of opportunity to rent an affordable home, we have to recognize in that conversation that tenants do not have bargaining power. That's why states that have passed good cause eviction are also states that have experienced really disparate housing market conditions for renters. You look at California and Oregon, New York, et cetera. I think this goes to rent stabilization too, frankly. You see this popular mobilization for these policies in reaction to market conditions which have disadvantaged renters even as the renter population continues to grow. So there is I would call it presumption, but I think that the burden of proof does shift under a good cause framework. Landlords will likely, as we've seen, I think from what I've heard from advocates in New York State, they're just seeing fewer cases brought for eviction because landlords know that they're limited in the level advantage that they used to have.
Again, not to belabor the point, but we talked about this too with we've had discussions a lot over the interim about the anti-retaliation statute.
Yes.
And I read this into the record before, so I'm not going to do it again.
Yes.
But want to know, all of this activity that we're trying to dissuade seems to be covered under the statute, under the anti-retaliation statute, if you're just facially reading it. So my question is, in practice, is it usable? Is it workable for the tenant? Why is this necessary with such a seemingly strong anti-retaliation statute? And we talked about this, about some of the improvements you could make to that. I think we're interested in doing that as well. But I want to hear why this is, as a supplement, is necessary to the anti-retaliation statute.
Again, I think that this committee can and should improve the retaliatory eviction law. I think that even if you did that, it doesn't get to the fundamental issue I just talked about, which is bargaining power. Retaliation is about how does a tenant respond legally to a harm that's already occurring. Good cause eviction is a preventative solution that, again, it raises the level of negotiating power for an individual or a group of tenants so that when they do decide to do something that is a protected activity, like forming a tenant association, complaining to the local licensing or code enforcement division, et cetera, they already know that they have protection. They're not facing the uncertainty that they have now, which is, well, I might face retaliation, and then I might get a day in court, and then I might get a judge who will hear me out, and I might have the evidence to win the case. There's a lot of mights. Those are all uncertainties. Those all create a chilling effect on the types of bargaining power that we'd like tenants to have. So if you go through the annals of this, for instance, in New York passed an improvement to their retaliation law, much like what we've talked in the briefing in January. They improved their retaliation statute, and then they came back 5 years later and they passed good cause eviction. So I think that an improvement to retaliatory eviction is needed, but it's not sufficient.
The last quick question is, so as drafted, it's unclear as to if municipalities are included. So this is enabling legislation for counties or the 24 jurisdictions, I think, Baltimore City and the counties. So I represent, the only municipality in my district is Tacoma Park, and they want, I was talking to the mayor last night, the night before, they want this. And so if we passed it as drafted, is it your position that the municipalities would be included, or how does that work? Or would the county have to do that and enact further enabling legislation, or do we have to change it here at the state level?
So two things. I want to answer your question, but also Senator McKay's earlier question. So why does the judiciary oppose the bill enabling counties to opt in? They may not want to see, Washington County or Garrett County have where tenants are bringing a defense that's going to be different from the defense that, for instance, a Montgomery County tenant brings. That's their preference. But the way the bill is written as it is to meet the judiciary's concerns, at least that a county would have a consistent law. So you would have Montgomery County, for instance, or Prince George's County opt into this good cause standard. But, Hyattsville or Tacoma Park wouldn't then create their own standard. So you have litigants coming into the district court at the county level, but the judge is going to have to discern, okay, what exactly is your address so I can know whether you have good cause or not. We understand that's a predicament for the judges, and we think we've allayed that concern by making this a county enactment legislation, enabling legislation. Now to Chair Smith's question. I'm not a home rule law expert, but I've looked into this. I think that the way the bill is written, it authorizes, obviously, the county legislatures in Baltimore City to opt in to the good cause standard. If a municipality wishes to also pass a good cause ordinance, they are able to do that under this bill, but only insofar as it's identical and not in conflict with the counties. That's as far as I've gotten with my research, and I think we could do more on that if necessary. But I don't see any room in this bill, Chair, for a municipality to create their own good cause that's different from the counties.
No. I was less worried about that, more worried about if the county does it, then the municipalities within that county are then enabled through this legislation. Just wanting clarity on that aspect of it.
Thank you.
Excellent. All right. Further questions for this panel? All right. Seeing none, thank you all very much. Thank you. All right. We'll now move on to the opposition, Mr. Enton and Mr. Caselli. And
I want my lunch. You owe me lunch.
Senator, this is yours. Thank you very much, Mr. Chairman, members of the committee. Robert Enton on behalf of the Maryland Multi-Housing Association. I don't know if this is the 10th year or the 12th year that this bill has been around. It started out as a Montgomery County local bill. Then it became a statewide bill. Then it went from being just cause to good cause. It's passed out of the House, came over here. You all did not pass it last year. This bill, if you just take a good look at it, and if you think that, put yourself in the position of a landlord somebody that rents out property. You have a contract like everybody else has a contract. And when that contract is over, either party can walk away. Now, while the landlord can't say to the tenant, you must stay, the tenant can say to the landlord, even though the contract has expired, I get to stay unless you can meet these criteria. And when you look at the criteria, I'm looking at page 5 of the bill, beginning like in line 8, okay? A tenant engaging in routine disorderly conduct. What does that mean, routine? In line 13, a tenant without reasonable cause. Who's going to determine whether it's reasonable cause or not? A tenant repeatedly committing, line 22, minor violations. What does repeatedly mean? Once, twice, 3 times? In line 29, a tenant habitually failing to pay rent when due. So all these terms are in there, and now you're going to say to the tenant, the burden is not on the tenant at all, who wants to stay beyond the term of the lease. The burden is completely on the landlord. They're the ones that have to go to court. They're the ones that have to show all of this. So I see that my time is up. I could go on and on, but this bill, if you want to pass a bill to deal with this bill needs a ton of work. And Mr. Chairman, if I could, I might have a bill that's coming up right now in the House. If there are no questions for me, I'd love to be excused.
All right, have a great day. See you later.
Thank you.
Mr. Chairman, members of the committee, Bill Castelli on behalf of the Maryland Realtors and our members, many of whom are property managers, were also opposed to the legislation. I'm not going to repeat what Mr. Enton said. We do think philosophically a lease has a start date, a termination date. Both parties agree to it. And for that reason, we would encourage an unfavorable report.
Thank you, Mr. Chair. Mr. Castelli, were you here at the time of the briefing that we had back in January?
Yeah, I was watching, but I was not.
I think I remember seeing you in the back watching. There was a gentleman from the Donahue companies who I found particularly fascinating. And he said, he was talking about building rental housing and how the developer puts a very small amount of his own money into the project and gets an investor to fund most of the cost. And the investors tend to be pension funds or other national organizations with money to invest, and then gets a mortgage for the rest. That, as I recall, that was his testimony. And he said Montgomery County is uninvestable, that there is no multifamily rental housing being constructed in Montgomery County because of legislation that's been passed both at the county level and at the state level. And I remember asking him, what about the state of Maryland? Is the state of Maryland investable? And he said, well, Frederick County is. That's where the action's happening. But beyond Frederick County, he was non-committal as to whether investment capital would be available to construct rental housing in the state of Maryland. So let me ask you, if we were to pass this bill, would this advance the state's goals of creating more rental housing or retard them?
I think the more, this question came up in the previous bill, I think the more control that property owners lose in terms of that property, the less control they have over tenants in the property, the less control they have over the property itself in terms of what they charge. And that provides less incentive for people to invest in property. And I think if you take a look in areas where there's a lot of supply of property, a lot of the complaints that tenants have over the difficulty of finding another apartment, making multiple applications, they're not as prevalent because the supply is meeting it. There's plenty of units for them to look at. So a lot of the problems that generate a lot of this legislative activity in places with a healthy balance of supply are much less.
Okay, thank you.
And thank you for your testimony, Mr. Castelli. It seems like the bill's drafters went through a lot of effort to kind of create a very exhaustive list of what sort of scenarios might arise where a landlord might still want to be able to evict someone. Could you give me some scenarios that you believe are missing from the bill that would also kind of be in line with the spirit of it in terms of making sure that there's stability in the market? But what are we missing that's making your members not want to support?
Well, I think a lot of our members have kind of a philosophical difference over what a lease is. You know, lease is part real estate law, part contract law. And so both parties agree to the start, both parties agree to the end. And I understand that there will be arguments made about power differences and, you know, you're kind of stuck if in one building if the landlord just wants a particular termination date. But there are choices to go to other places, other units. So I think for us, and I can only speak for our folks, they believe that the lease covers that. You know, both parties agree to when it's going to start. Both parties agree to when that lease is going to end. I do recognize that the legislation has made a lot of effort to address concerns raised by, you know, panels like ours in the past. We appreciate that, but fundamentally, I think they still believe that because both parties agree to it, that should be the end of the conversation.
I understand. So the list includes things like if there's illegal activity, the landlord could still choose not to renew the lease. If the person is not paying their rent, if the person's engaging in disorderly conduct, if the person substantially breaches their lease, if they are keeping, I guess, dangerous conditions on the property, all those other things. So it's not that the landlords want to be able to cite a specific reason. Your members want to be able to have no reason. Is that what I'm understanding?
Well, so we would say it's not an eviction. I mean, a lease term is for a specified person. So once the lease ends, there is no eviction. There's no longer a lease. But I would say you would still, as a property owner, to the extent a tenant disagrees with whatever reason, good cause that you're giving, you would still end up in court where you wouldn't have that necessarily that process that you would have to go through under current law.
So I just want to make sure I'm clear. It is not the exceptions that are provided in the bill that's an issue. They could name every scenario under the sun. Your issue is philosophical. You want to be able to continue to not renew leases for no reason at all.
The reason would be the lease has ended.
Thank you. I appreciate your testimony.
All right. Further questions from the committee? Excellent. Thank you very much. Thank you. All right, with that, that'll end the hearing for Senate Bill 651. Senator Hershey here? Senator West, how many witnesses do you have? You want to, 3? You want to just go real quick? Yeah. Senate Bill 954.
So, it's a, everybody's cleared out. So it's a pleasure to be here, even in front of a largely empty room, to present Senate Bill 954, which is a constitutional amendment. You will recall last week the state judiciary came with lots of witnesses to present a bill to change how we elect circuit court judges. This is an alternative that I want to present to you this afternoon. So as I stand here, I get the distinct feeling of deja vu all over again. On several occasions during my 4 years in the House of Delegates, as well as during the past 7 years that I've served on this committee in the state Senate, the state judiciary has come in with a bill to, in one way or another, totally eliminate the people's right to elect their circuit court judges. Just last week, we heard last year's version of this bill, of their bill, but you could have come to the Maryland General Assembly Judiciary Committee or the Senate Judicial Proceedings Committee 57 years ago, and have heard essentially the same discussion of issues on the question of circuit court judicial elections. I remember well, I first encountered this issue in 1988 when I was a senior in high school. I was a member of the debating club. Our final debate had the topic resolved that the voters of Maryland should vote to ratify the proposed new constitution for the state. A special constitutional convention that year had drafted a new constitution, and a special referendum election was being held that spring to decide whether to adopt the new constitution. My side, which took the affirmative of the argument that the voters should ratify the Constitution, won the debate, but the new Constitution did not fare as well. The voters turned it down. The principal argument made by the opponents of the proposed Constitution back in 1988 was that it contained a provision taking away from the voters the right to elect their circuit court judges. So this issue has been on the front burner for at least 57 years, and we are now dealing with the same issue. In the judiciary's formulation, it has always been presented as an either-or choice. Either we stick with the current system in which every single circuit court judge appointee has to run in a contested election, or instead we follow the recommendation of the judiciary and totally eliminate all contested elections for circuit court judges. Let me quickly deal with the bill presented last week by the judiciary. It would, as is always the case with bills advanced by the judiciary, completely eliminate all contested elections of circuit court judges. On the judiciary's bill, if a gubernatorial appointee received 50% of the vote plus one vote on the Senate floor, the appointee would be confirmed and would not run in a contested election, rather in a retention election. As Judge DeMay admitted last week in response to one of my questions, every single judicial nominee for the state's district courts and for the state's appellate courts over the course of the first quarter of the 21st century, as the past 25 years, has received at least 50% of the vote plus one vote in the state Senate. As gubernatorial judicial appointees are always all confirmed. Then, under the judiciary's bill, the confirmed circuit court judges would run in retention elections. In Maryland, retention elections have been charade elections because no judge has ever come close to losing a retention election. In a retention election, no money is raised or spent, there are no opposing candidates, and there's no campaigning. And so the incumbent judge always wins, and wins overwhelmingly. I think one of our senators, Senator Henson, asked a question about this last week, and the response of Judge DeMay was she wasn't aware of any judge ever losing a retention election, and I texted at the time, I am aware that no judge has ever lost a retention election. But a system in which the governor essentially all by himself controls judicial appointments has serious problems. In the 1970s, 2 consecutive governors appointed a long line of white men to the Circuit Court for Baltimore City. And the Monumental City Bar Association, the Black Bar Association in Baltimore City, recruited and supported black opponents in contested judicial elections. Because Baltimore City had become a majority-minority city, many of the black judicial candidates won, and in the process ensured that the Circuit Court for Baltimore City reflected the diversity of the city's population. If the judiciary's bill had been in effect in those years, there would have been no opportunity for contested elections, and the Circuit Court for Baltimore City would have remained mostly white. In the 1990s, Paris Clendening took a very partisan approach to appointing judges. During his 8 years in office, he appointed just under 120 circuit court judges. All but 4 of those judges were Democrats. Eventually, highly qualified district court judges who had been repeatedly passed over because they were registered Republicans, realized what was happening and began to challenge the Glendenning appointees. They won a number of elections, particularly in the state's rural counties, thus ensuring that our judiciary more closely reflected the diversity of our state population. If the judiciary's bill had been in effect at that time, there would have been no opportunities for contested elections, and the state's judiciary would have become regarded as the province of a single political party, not, in my view, an appropriate state of affairs. Up until recent years, the number of women on the circuit court bench was shockingly low. During the early years of this century, female candidates, passed over by our governors, began to run against the appointed circuit court judges and won a number of elections, thus ensuring that our judiciary more closely reflected the diversity of our state population. If the judiciary's bill had been in effect during those years, disappointed female applicants for judicial office would have been out of luck. Realizing that a system that required that all circuit court appointees run in contested elections was flawed, and that a system that eliminated all opportunities for Maryland citizens to ensure appropriate diversity on the bench was similarly flawed, in 2017, my fellow delegate, Eric Barron, and I sat down and did some creative thinking on this issue. You may recall this morning, we celebrated Eric Barron's tenure as the U.S. Attorney for the state of Maryland. And he received deserved lusty applause for the job that he did. The product of the thinking of Delegate Barron and me was memorialized in House Bill 828 in 2017, which we both co-sponsored. And this bill, which is the subject of this hearing, Senate Bill 954, is essentially that same bill, but with a couple of improvements, which I'll discuss in a moment. By the way, not long ago, I spoke to Eric, and he authorized me to remind you that he fully joined me in support of House Bill 826. Indeed, he sat next to me during the presentation before the House Judiciary Committee that afternoon. On that occasion, Delegate Barron and I thought outside the box and came up with a proposed compromise, which we believed would effectively eliminate most circuit court judicial elections, but would retain the possibility of an occasional election if the circumstances warranted it. In my view, this compromise would represent a win-win solution for both sides. Each side would get most, not all, but most of what it wants. Now, let me explain to you the details of this suggested compromise and explain why, in my view, it would be an excellent solution to this decades-old conundrum. As I mentioned a moment ago, there is a bill in your folder that contains the details, but it's written in legalese, so I'm going to explain it to you in plain English. The compromise would make a structural change in the appointment process. Upon a circuit court vacancy, the governor would not appoint, but would rather nominate a replacement, and would probably use the judicial nominating commissions. Frankly, the nominating commission should be codified into law, but that would be a separate bill that I would be pleased to either sponsor or certainly support. The governor would nominate a replacement, unlike right now when that replacement goes immediately onto the bench and runs in a contested election to retain his or her seat. Under Senate Bill 954, that nomination would instead go to the state Senate for confirmation. In this respect, the judiciary's bill and my bill are identical. In both bills, the governor would nominate a replacement. It would go to the state Senate for confirmation. Now, here's the interesting component of this bill. If the judicial nominee were to receive less than 50% of the vote, the nomination would fail. If the judicial nominee were to receive over 80% of the vote, the nominee would be seated and would not face an election. If the nominee were to receive over 50%, but not over 80% of the vote, thus indicating that there is some significant opposition in the state Senate to confirmation of the nominee would be confirmed, would be seated on the bench, and would have to run in a contested election as at present. So you've got the 80% hurdle. A couple of things about this proposal. First of all, Given the track record of judicial appointments in the state Senate over the past 25 years by both Democratic and Republican governors, and remember, so far in this century, Democrats have occupied the governor's mansion almost equally as Republicans have. So we've had 12 years of Democrat governors and 12 years of Republican governors. Given the track record of gubernatorial appointments of both Democrats and Republicans, it seems quite likely that nearly all of the gubernatorial nominees to the circuit courts would receive over 80% of the vote in the state Senate. During the term of a Democratic governor, the governor's nominees are almost always confirmed by Maryland's overwhelmingly Democratic state Senate. Even during the term of a Republican governor, if the records of Governors Ehrlich and Hogan can be relied upon, the governor's nominees nearly unanimously are confirmed by the state Senate with over 80% of the vote. Thus, it can be confidently anticipated that nearly all of the governor's circuit court appointees would win confirmation and would not have to face contested elections. This would especially be the case if the governor were to take care to appoint people who are qualified, who are ethically sound, and who are diverse. I'll come back to discuss diversity shortly, but based upon many years of observing gubernatorial judicial appointments, I have found it very rare for a judicial appointee of the governor to be subject to criticism on the grounds that the appointee is unqualified or has ethical issues. Part of that probably is the result of the Judicial Nominating Commission process, which only tends to give the governors recommended appointees who are competent and who are ethically sound. Now, turning to the diversity issue, over 20% of the members of the state Senate are black. Over 20% of the members of the state Senate are Republican. Over 20% of the members of the state Senate are female. If a future governor were to fail to keep the need for diversity in the bench in mind, it is possible, even likely, that disgruntlement would grow among the senators who are members of the demographic group being overlooked. That disgruntlement would get communicated to the governor, and if the governor brushed off the concern, one or more future appointees could receive less than 80% of the vote. This might embarrass the governor, but it would hold his feet to the fire when making future appointments. Now, let me venture a couple of additional ways in which this bill would constitute a huge improvement over the current system. First, and very importantly, this bill provides that in the event of a future contested election of a circuit court judge, the only candidates qualified to run against the governor's choice would be lawyers who had applied for a judicial vacancy, had undergone the Judicial Nominating Committee process, and had been put on the list forwarded to the governor of candidates whom the JNC had found to be, quote, fully professionally qualified, close quotes, to be a judge. This is the tweak that has been made to this bill since Delegate Barron and I first introduced it 10 years ago. So Senate Bill 954 would eliminate the oddball candidates who file their candidacies for circuit court judge and on rare occasions actually managed to get elected. And there have been one or two of those cases within the past 10 years. In fact, within the past 5 years, one in Anne Arundel County and one in Prince George's County. Secondly, one objection to the current system is that many of the most qualified attorneys decline to apply for circuit court openings because under the current system, as soon as the governor appoints them, they immediately have to close down their law practices, turn over all their clients to other lawyers, get sworn in, and then later on run in a contested election. If they lose the election, they're left having to try to rebuild their law practices from scratch mid-career. Because of this possibility, many good lawyers, many fine lawyers, decline to apply for appointment to the circuit court. If my suggested compromise should be adopted, this problem would be eliminated. First, as noted earlier, nearly all the governor's appointees would be confirmed by over 80% of the vote in the state Senate and would not face an election at all. Secondly, a nominee would not have to close down his or her law practice until after the confirmation vote. If the nominee were to fail to receive 80% of the vote, the nominee could assess the nature of the opposition and could make an intelligent decision under the circumstances whether to get sworn in as a judge and face a contested election or alternatively to decline the appointment and continue to maintain his or her law practice. So we're going to get a much higher quality of applicant for the circuit court. Another objection to the current system is that in larger counties, each election year brings sitting judge tickets comprised of all the judges required to stand for election. If there's a challenger to the ticket, the imperiled sitting judge is always the one whose last name falls closest to the end of the alphabet. As a guy names his name begins with W, I know that form of discrimination over the course of my life. I was always last in the milk and cookies line back in elementary school. As we all know, candidates are listed alphabetically on the ballot, and voters tend to vote more frequently for whose candidates whose names appear at the top. If the compromise I'm presenting is passed, and most judicial nominees are confirmed with over 80% of the vote, as I firmly expect will be the case, the rare nominee who fails to get 80% will most likely be running alone in a head-to-head match against a challenger rather than as part of a sitting judge ticket. Thus, the days of sitting judge tickets will be over. And now let me emphasize that no system of choosing circuit court judges is perfect. In this regard, there's no such thing as perfect. The current system in which every single circuit court judge must run in a contested election is badly flawed. The judiciary's proposed alternative has its own serious flaws, some of which were pointed out by senators asking questions of the witnesses last week. The vital need for diversity on the bench is why future governors cannot be given unilateral power to appoint judges. The state constitution must contain a mechanism to allow voters to weigh in when a governor ignores the need for appropriate diversity in the judiciary. And that's where this bill comes in. It's not perfect. It is possible to hypothesize a situation in which an abuse could occur, but in my view, it's far preferable to any of the alternatives. In conclusion, I believe this suggested compromise will finally cut the Gordian knot which has tied up the General Assembly for 57 years. Delegate Barron and I approached this issue with fresh eyes. While our approach does not grant either side an unconditional win, thinking outside the box in this way offers the General Assembly an opportunity to adopt a creative compromise. It would eliminate nearly all contested circuit court elections while still providing a necessary check on unchecked gubernatorial appointment authority. And for these reasons, I urge a favorable vote on Senate Bill 954 and would be pleased to answer your questions.
Thank you very much, Senator. Questions from the committee. Senator Sidnor.
So in the judiciary's position paper, they say that this bill proposes a special session for when the Senate in such instances as some sort of a vacancy, and they expressed a concern about the likelihood and potential resultant delays.
Yeah, I can easily answer that one. So this bill and the judiciary's bill are identical in that no judge takes office until the judge has been confirmed by the state Senate. So if a judge dies in, say, June, under both bills, the judiciary bill and my bill, the governor's nominee would be presented to the state Senate when next the state Senate meets. No difference between the two bills. There's a delay. Now, let's face it, it takes a while to get to the point that the governor makes such an appointment. The people have to process the death, then advertisements are run, then people have to fill out a very lengthy application form and get it filed. The forms are provided to all the specialty bar associations as well as the JNCs. Interviews are set up with the specialty bar associations first. They have an opportunity to then to send letters to the JNC with their recommendations. The JNC then sets up its own interviews. Those interviews occur. The JNC then reviews all the letters as well as considers the results of the interviews. It comes up with its decisions. It sends its own letter to the governor with the recommended names. The governor then considers those names, schedules his own set of interviews with the candidates, conducts the interviews, and then typically some time passes before the governor finally makes his appointment. So the process takes time. But the bottom line is, in both my bill and the judiciary's bill, it's exactly the same. Nothing happens until the governor's appointee comes before the state Senate for a confirmation vote. I will add, in my bill, there is a provision which is not in the judiciary bill to allow the governor, if he wants to call a special session of the state Senate to consider judicial appointments. And finally, let me note that I just lost my train of thought. I'll come back to it. Let me come back to it, and give me another question. I'll come back to finish up this one.
One other question.
Oh, I know what it is. I know what it was.
Go right on ahead.
I ascertained last week from Judge DeMay, or maybe it was the Chief Justice, that we have about 100 retired judges, people who are over 70 years old, who the Chief Justice can call back to fill gaps in the judiciary. So, and that's frankly how we've solved this problem up until this point. When there is a vacancy, and the vacancy has to maybe in a county with only one judge, the vacancy has to be filled. The Chief Justice will assign one of the retired judges to sit in that county until the new judge is appointed and confirmed.
And the last question I had is, during your testimony, you had talked about folk who have gone through the process, they've been vetted and the like. And qualified to be a judge. I'm curious, in your mind, what makes you what are your standards? And I mention that because
in terms of vetting,
right? Because for me, you're being an attorney, practicing in whatever area after a certain number of years. You could be a judge.
Well, that's part of the vetting process. I was on the State Bar Association's Judiciary Committee for about 4 years. Mm-hmm. And once or twice a month, we would all travel to some part of the state to interview candidates for judge. So I spent 4 years engaged in lots of interviews with people who wanted to be a judge. So the first thing is, how long have you practiced? Mm-hmm. Do you have enough experience practicing law? And practicing law in a litigation setting, in a courtroom setting, to qualify yourself to be a judge.
And that's the bias that I've always thought existed in those systems, is you have to be a litigator to be a judge. And I remember speaking with a judge on our, at the time, Court of Appeals, and asking, do you think you have to be, you had to be a litigator to be a judge? And he was like, no. But that's the bias that exists in the system against attorneys who happen to practice in other types of settings and aren't necessarily litigators. I mean, we've all been trained to read the law.
To the extent the bias is a significant bias, it exists right now. And it would exist under the Judiciary's bill as well as under my bill.
Oh, it does
because
exist.
Both bills rely on the Judicial Nominating Commission to send names to the governor.
Right. Okay. Thank you.
Sure.
From the committee. All right, seeing none, thank you very much, Senator West.
Thank you.
All right. We have 3 witnesses signed up for your bill. Tony Torch, John Torch, and Mr. Murphy, Billy Murphy. I don't see anyone here for that. Okay. No, there was all in favor. All right.
I read the Torch's opposition. It relates to them.
Okay. That's what they all. That's what they all say. All right. With that, that'll conclude the hearing for Senate Bill 954. I see Senator Hershey's here, so I'm going to bring him up since he has members of the judiciary here. So Senate Bill 877, Senator Hershey.
Yep.
Good to see you.
Thank you very much, Mr. Chairman and members of the committee. For the record, Senator Steve Hershey to present Senate Bill 877, which is quite simple bill. It simply is a local bill that will increase the number of sitting resident judges of the Circuit Court for Queen Anne's County from 1 judge to 2 judges. Mr. Chairman, I recognize that there is a process established by the judiciary that certifies the judgeships to the General Assembly, but also recognize that there's another process that we can add judges, and that's through the legislative process, which is why I'm here today. I know that there is a letter from the judiciary in your bill file, as well as the report that they had sent. I think it's important to recognize that they have evaluated through the process that they use, the National Center for State Courts, NCSC process that determines the evaluation and method to proceed with recommending judges. The judiciary has identified 1 trial judge that is necessary for St. Mary's County. They also identified that an additional circuit court judge would be made or necessary for Kent County, but are not moving forward with that recommendation. I think it's important to recognize in their comments, they've talked about the model that they've been using for a number of years. It has been dramatically affected by COVID. They've gone back and forth and looked at data pre-COVID and post-COVID. The recommendations for FY budget year 2024 is the first that they have started to look at a more broader guidance instructing the judiciary to monitor filing trends and case backlog to make the most accurate assessment of future workload. They've also talked a lot more about including the complexity of additional case types, such as criminal cases in the district court and jury trial prayer and criminal appeals for the circuit courts. And I think that is one of the things that you'll see are quite important and maybe a little bit different in Queen Anne's County. They do give a number of data that is provided further on in the document. Interestingly, the number of jury trial prayer and criminal appeals as a percentage is much higher in Queen Anne's County, and thus is one of the reasons that you'll hear from us on requesting this additional judge. In Kent County, although it was recommended that they receive an additional judge, as well as some other places, the facilities are simply not ready for an additional judge. You'll hear that Queen Anne's County is very proud of the brand new courthouse that they had built recently, and it does have 2 circuit court trial rooms in it and space for a second circuit court judge, which has always been the plan when that was built and just recently opened. So with that, Mr. Chairman, I'd let you also know that the Queen Anne's County Commissioners are fully in favor of this. And again, it has been requested for some period of time, and we look towards the legislature to help us fill the need that we have in the judiciary in Queen Anne's County by allowing 1 more circuit court judge. So with that, Mr. Chairman, I appreciate the committee's indulgence on this. Happy to answer any questions and ask for a favorable report.
Excellent. Thank you very much, Senator. We'll take questions at the end of the panel.
Thanks.
And whoever would like to come to take the podium next.
Mr. Chairman, Mr. Vice Chairman, members of the committee, my name is Judge Lynn Knight. I am the sitting judge of Queen Anne's County Circuit Court. We have 1 judge and 1 magistrate to handle the nearly 1,500 cases that are filed each year. I'm aware that Chief Justice Fader was before you last week on St. Mary's County. He mentioned 3 other jurisdictions that requested judgeships, and we are one of those jurisdictions. My predecessor, Thomas G. Ross, first began this pursuit 19 years ago. 19 years ago, we started looking for a circuit court judge, and Air County took on the large financial burden of building a new circuit courthouse because the operations in the historic courthouse simply could not handle the extra judge and the staff that went with it. In June of 2019, we opened a new, modern, fully electronic courthouse that contains actually 4 courtrooms, 4 judges' chambers, and adjacent offices for support staff. Then we hit COVID, and so everything kind of changed for the judiciary. But we are currently at our pre-COVID levels with air filings. We have also seen a 167% increase in domestic violence cases, 212% increase in child custody and child support modifications, and 110% increase in special immigrant juvenile classification cases, to just name a few of the things. I have issued 190 orders last year to mediation in an attempt to reduce trial time. We do use senior judges, but in 2024, 4 of our counties have one judge. 2 of those 4 had a vacancy for more than 8 months. So our pool was smaller for senior judges, and those resources were all used up by those 2 counties. It became very difficult to have a senior judge sit in. As I said, our commissioners are fully supportive, and we ask that you support this bill.
Good afternoon, Chairman Smith and members of this committee. My name is Catherine Hager. I'm the clerk of the court for Queen Anne's County, and I thank you for the opportunity to testify in support of Senate Bill 877. I worked in the clerk's office for the Circuit Court for Queen Anne's County for 19 years, and I've had the privilege of serving as clerk of court since 2018. When I started working in Queen Anne's County in 2006, leadership at the Administrative Office of the Courts informed us that one reason Queen Anne's County would never receive a second judge was due to the lack of space in our historic county courthouse, the one that was built in 1796 during George Washington's presidency. At that time, the Honorable Thomas Ross, the former administrative judge, and the Honorable Scott McGlashan, the former clerk of court, worked together to address this challenge by creating the new courthouse committee. This committee, which I was a member of, was made up of members of the local bar and community stakeholders. The committee was tasked with exploring the county's courthouse needs, as it was 19 years the need for a second judge was already being felt in the county. In response to security assessments and the needs of the court, Queen Anne's County made a significant financial investment in the future of the court system by approving the construction of a new courthouse that would accommodate 2 judges with the 2 jury trial courtrooms. The process from land acquisition to the completion of the new courthouse spanned 10 years and 3 different sets of county commissioners, highlighting the county's commitment to addressing the need of a second judge and improving the court system. Before joining Queen Anne's County, I was the Chief Deputy Clerk for Howard County Circuit Court, and with 29 years' experience, I have seen firsthand how Queen Anne's County, a high-performing court, manages a heavy caseload with just 1 judge, though it comes through with significant challenges. The clerk's office processes about 4,000 pleadings a month requiring some type of review or action by our sole judge. I wish to thank Senator Hershey for sponsoring this bill and respectfully ask for a favorable support of the bill. Thank you.
Good afternoon. Thank you for this opportunity to speak. My name is Lance Richardson. I'm the state's attorney for Queen Anne's County. I've spent the last 30 years practicing in Queen Anne's County, and I'll be very candid why we need this circuit court judge. We have a wonderful district court judge. We only have 1 district court judge. That is Judge Frank Cradaville, and he's my old boss and a great guy, but he's probably the toughest judge in the state of Maryland. And because he's the toughest judge in the state of Maryland, in Maryland, any case that carries a penalty of potentially more than 90 days has a right to a jury trial. That's about 90% of the criminal matters we handle. So last year alone, we had over 500 prayers for jury trial, removing our criminal cases from our district court to our circuit court. So Judge Knight is burdened with those 500 criminal cases that are basically brought to her. Additionally, as a state prosecutor, we are held to speedy trial standards. We have 180 days to take a case to trial in the circuit court from initial appearance to the completion. And I have 2 pending murders. We have a robust felony criminal docket with embezzlements, manslaughters. Those cases often take 5 days to try. I cannot find calendar dates in our circuit court with 1 judge available. It's just not feasible. And if we don't meet our speedy trial constraints, those cases could be dismissed. It's a public safety issue, and frankly, this would be a great benefit to the citizens of Queen Anne's County and to the state of Maryland. Many of the criminal defendants I prosecute are not from Queen Anne's County. they're passing through on the way to the beach, et cetera. It would be a benefit to the state of Maryland to have this second circuit court judge, and I would ask for favorable consideration, and I appreciate your time here today. Thank you.
Good afternoon, Mr. Chairman, members of the committee. For the record, Bruce Bariano. I'm here on behalf of the county commissioners of Queen Anne's County. As was indicated, they strongly support this. Let me just say briefly a couple of other things. First of all, as I chatted with the Madam Clerk of the Court, probably not known in the fiscal note, there is no additional expense. There's an open vacancy in the clerk's office right now, and that could be filled by the clerk for this court for this particular new judge, if so. So please bear that in mind, that the staff available would not be at any additional cost to the state of Maryland. Lastly, and with utmost respect to the judiciary, I read through everything, and as Senator Hershey indicated, the administrative office of the courts looks at things more globally and sort of within a box of a formula and national standards. And hopefully, from what you heard from the judge herself, from the Madam Clerk herself, and from the state's attorney, there's a lot of uniqueness in Queen Anne's County, a lot of uniqueness, and the need is real. And while the benefit of opinions and recommendations of the administrative office are extremely helpful to the legislature, as you all know, as senators, and the history of the legislature, you create the courts. You create the number of judges. That is your legislative prerogative and authority and ability. And would very strongly urge, there's just an empty courtroom there. I mean, I think a case has been made of the uniqueness for Queen Anne's County, and would please urge a favorable report so that justice can be done in Queen Anne's County in a swift and efficient and productive fashion. Thank you very much.
Thank you. This question any of you can answer. And again, I think when I first sat down and the sponsor began speaking, all right, it's easy, one judge. But then, as Mr. Bariano had pointed out, the judiciary, they don't say they oppose, but they provide an explanation of non-support. They have a system that's in place, and even with our authority to increase or decrease, I'm trying to understand, why should we treat you all differently and outside of the system that the court kind of has in place to grow and to meet the needs of the various jurisdictions? That still hasn't come across to me in anyone's testimony.
Well, I think I can answer that. All the circuit courts are unique in their own way in the state of Maryland. They're designed that way. You've heard about elections, you know, what represents your community. I may handle a case very differently than a judge in Baltimore County handles a case, but we're all treated the same. This formula treats every county circuit court exactly the same. They plug in the numbers. It's all by new filings. Well, that doesn't represent what is happening in our county. And so it's one size fits all, doesn't necessarily fit. And if you read their letter of non-support, they say we make a good case. Mm-hmm. They just aren't ready to come to the table with that. But we've been asking, I've asked 3 years to be put on this panel to be here, and my prior judge asked for 15 years. And so it's time that we look at this a little bit differently than that formula.
So the formula, I guess, was created within the judiciary.
National State Courts is based by the national level, but it was done in 2017.
Mm-hmm. And
it's not a state court issue.
All right, so you're saying that our judiciary, they're not, help me to understand this.
They've adopted they're using the national formula. They don't have their own formula for the state of Maryland.
And and again, I'm asking out of ignorance because I don't know. This formula that's been adopted, was this adopted in what's Rules Committee or something? I mean, I'm trying to understand if there's something that can be done within the judiciary to deal with a formula that doesn't seem to work for you all. Is that a separate issue?
Well, if you read their letter of non-support, that's the one, like the last paragraph that they bring up, is that they are looking at looking at different models and be able to come back to the table in 2028.
Not soon enough for you. Okay, thank you. Is it Mr. Richardson? I don't.
Yes, sir.
I have a question for you. And since you're here and it's a little off the bill, do you have a case management system?
Do we have a case management system? Yes, sir.
Computerized system?
Yes.
May I ask what system you use?
We're switching right now. We have been using Software Unlimited. We're switching over to Carpel.
Thank you very much.
Is that it?
Yep.
No, yeah, actually. No, how do you fund that? It funds through the county or through the
county? Yes, sir.
Excellent. That's great.
Thank you.
All right.
You get points for that?
Extra bonus points for that one. Thank you for the clarification on the fiscal note, because we're going to make a run at it anyway for B&T, but we'll be in discussions with Chief Judge Morrissey and B&T, so we'll be in touch again. But further questions from the committee? Excellent. Thank you very much. Thank you.
Thank you, Mr. Chairman, members of the committee.
We now have Senator Charles with Senate Bill 681.
Waiting on one person. Come on, man. Was she outside at all? No. Okay. What's that? Yeah, you'll come back up here and I'll see. All right. Good afternoon, Chair Smith, Vice Chair Wallstriker, and honorable members of the Judicial Proceedings Committee. For the record, my name is Senator Nick Charles, and I'm testifying in support of Senate Bill 681. This bill is a crucial step forward in ensuring clarity and fairness within our healthcare system, particularly for patients and professionals involved in medical malpractice cases. Hospitals are complex institutions where care is delivered by not only doctors and nurses, but also a wide range of other skilled professionals. Many of these individuals work as employees, contractors, or agents of the hospital. However, current law does not always clearly recognize these professionals within the state's malpractice statutes. This creates unnecessary legal gray areas, especially when patients seek accountability for medical harm. Senate Bill 681 addresses this issue by updating the definition of healthcare provider. Under the Maryland Healthcare Malpractice Claims Act, by doing so, it ensures that all licensed professionals working in a hospital setting and appropriately recognized as healthcare providers under the state's malpractice laws. This is not an attempt to increase litigation or expose providers to unwarranted claims. Rather, it is about ensuring that the legal framework is clear and accurate. Senate Bill 681 helps provide certainty for both patients seeking justice and the healthcare professionals working in hospitals. When a patient seeks care in a hospital, they should have the confidence that the legal system will fairly recognize their case regardless of which licensed professional provided the care. In Maryland, medical malpractice claims are distinct from personal injury and wrongful death claims. Medical malpractice cases involve complex medical issues that require specialized knowledge, and the malpractice statute ensures that these cases are handled by experts who can properly evaluate the standard of care. The statute also sets guidelines for expert testimony and appropriate medical standards. The separate malpractice statute ensures that healthcare providers are held to a high standard of care, promoting accountability and protecting patients from negligent practices. Unfortunately, the medical practice statute has evolved in a way that has left certain provider groups unaddressed or unclear. This has led to confusion and misrepresentation, particularly for hospitals employing a wide variety of medical providers. By clarifying the definition of healthcare provider, Senate Bill 61 ensures that any claims arising from medical care delivered in a hospital setting will be handled under the established malpractice statute. This will guarantee that medical malpractice cases are evaluated under the proper legal framework designed to address the complexities of such a claim. It's a common sense update to Maryland's healthcare laws that promote fairness, transparency, and accountability, and I urge the committee to support this bill and take this important step towards ensuring that all healthcare providers in Maryland are held to the appropriate legal standard. So today I have with me Jake Whitaker, who's the Assistant Vice President of Government Affairs and Policy for Maryland Hospital Association, and Robin Elliott. She'll be joining us shortly. She's on her way. She's one of the managing partners for Public Policy Partners, and she'll be representing the nurse midwives. Thank you.
Great. So thank you, Mr. Chair and members of the committee. I'm Jake Whitaker on behalf of Maryland's hospitals and health systems, here to strongly support Senate Bill 681. As Senator Charles mentioned, this bill simply clarifies the healthcare provider definition in the Medical Malpractice Act so that when claims arise from the delivery of medical care in hospitals, we can ensure those actions are evaluated under the appropriate medical malpractice statute. And I think we've drafted this bill very narrowly, so it only impacts those folks that kind of common sense tells you will be impacted and that do medical care. So we're not talking about hospital lobbyists or security guards or administrators working at hospitals. We're really talking about folks like respiratory care specialists and x-ray technicians that I think we could all agree are medical providers. Unfortunately, though, the medical malpractice statute has evolved to specifically name individual provider groups under the Medical Malpractice Act. And this has become a significant issue for hospitals who are addressing our historic and national healthcare workforce crisis. Maryland hospitals are proactively working to expand our workforce by adopting innovative care delivery models and new professions such as virtual nursing or x-ray, or limited scope x-ray technicians to better meet those patient needs. So as I mentioned, emerging roles like new x-ray technicians and mobility technicians who assist patients with movements and also help nurses really kind of stretch out their ability to serve more patients. We just want to make sure that this legislation will help hospitals support innovating and developing these new positions and not punish them for creating new positions just because they're not specifically listed under the medical malpractice statute. And before I conclude here too, I just wanted to address a couple of the opposition. So I saw that the Right to Life had some concerns about this legislation, and I want to be very clear that this bill does not affect reproductive health or women's health whatsoever. This bill simply says that you need to file claims for certain individuals under the Medical Malpractice Act rather than under personal injury. Additionally, I saw that the Maryland Association of Justice had some concerns about the language being kind of tight enough to make sure that we're only capturing medical providers. And so we're happy to work with stakeholders to make sure that we're really kind of clarifying the intent of this bill. And with that, I'll ask for a favorable report for Senate Bill 681. Thank you.
Good afternoon, members of the committee. My name is Robin Elliott. I'm here today on behalf of the Maryland affiliate of the American College of Nurse Midwives in full support of the bill. So nurse midwives work in hospitals. They are part of the care team. And one of the main reasons why they are in support of the bill is they want to make sure that all clinicians participating in the care team are under the same law. I see in this committee, including the bill sponsor, Senator Charles, and some other members of the committee, members who used to be on the House and Government Operations Committee. So I think everyone is aware that the health professions evolve. New ones get added. And so to have to update the statute every time may not be the most effective way to really safeguard the patient care teams. So with that, I would very much appreciate a favorable report and happy to work with the committee and the panel to answer any questions.
questions from the committee for the panel? All right, Senator, thank you all very much. Thank you. All right, with that, that'll conclude the hearing for the proponents of the bill. We'll now switch to the opposition panel, and we'll hear from Deborah Brocado and Patrice Clark. Maryland Right to Life and the trial attorneys coming together.
Absolutely.
Yeah.
Good afternoon, Mr. Chairman, members of the committee. My name is Patrice Meredith Clark. I'm here on behalf of the Maryland Association for Justice, and we ask an unfavorable report on Senate Bill 681. 50 years ago, this General Assembly enacted the Healthcare Malpractice Claims Act. The act limits the rights to patients. It limits the rights for injured Marylanders to receive compensation for injuries against, quote, a healthcare provider for medical injury. It imposes special requirements on filing suits, and it imposes a special cap. In some cases, that special cap is less than half of what a person can recover in the personal injury context. Healthcare provider was and is a specifically defined term. Senate Bill 681 would redefine healthcare provider to include an employee, agent, contractor of a hospital who is licensed, certified, registered, or otherwise authorized, to render healthcare services in Maryland. As written, this bill is ambiguous and invites a slew of litigation. What does otherwise authorized mean? Who is doing the authorizing? What does healthcare services mean? It's not defined in the code. Senate Bill 681 would allow hospital corporations to unilaterally authorize any or all of its employees or even independent contractors to render healthcare services in an effort to avoid appropriately compensating victims. It is not good legislative policy to indiscriminately shield hospital corporations from responsibility for preventable harms caused by the negligence of their employees, or their agents, or their contractors. For these reasons, we urge an unfavorable report. Thank you very much for your time. I apologize for my laryngitis.
Good afternoon, Senators. I'm Deborah Brocado with Maryland Right to Life, and on behalf of our board and our members, we do ask for an unfavorable report on Senate Bill 681. There is a concerted effort to force hospitals and hospital personnel to provide abortion services. This bill adds to that pressure by putting hospitals and hospital personnel at risk for litigation, particularly when it comes to medical abortion or the dangerous abortion pills. The Lozier Institute and National Institute of Health have studies showing that there has been an increased emergency room visits after medical abortion. In Georgia, Amber Thurman died from sepsis caused by incomplete abortion after taking the dangerous abortion drugs. She was pregnant with twins. Some of the remains of the babies were left inside her, and she developed a total body infection. The prescriber did not follow her. She went to the hospital and may not have known why she was so sick and may not have disclosed to the hospital personnel that she had taken those pills. The most common way for these pills to be prescribed is through telehealth. There is no in-person exam to show what other conditions might be present, like the presence of a multiple pregnancy, which obviously would increase the danger of remains of babies being left inside after taking these abortion pills. There are also other dangers as like ectopic pregnancy, or if the woman has already had a miscarriage, or some other coexisting conditions. Prescribers of the abortion drugs are directing the women and girls to go to the ER and claim a natural miscarriage rather than admit they had taken these abortion pills. Hospitals and hospital personnel are forced into participating in abortion. Prescribers are transferring accountability to others who did not prescribe these pills. Prescribers need to be held accountable for the care of the women and girls after taking these pills, not the hospitals. Maryland has shield laws protecting the abortion industry. They do not require the reporting of abortion statistics. Please find a way to put the accountability, liability, and responsibility onto those prescribing these dangerous abortion pills, not on the hospitals. We do ask for an unfavorable report on Senate Bill 681. Thank you.
Wow. Senator Charles.
Thank you, Mr. Chair. Appreciate you.
My question for actually both of you all, in terms of reading your letters, are there any amendments that you would offer? I know you saying you oppose the bill, but I know one of the things you brought up about janitorial malpractice, being a major issue. Is there anything that you would offer up so that we can make the bill a better bill for you all?
I would say that the MAJ is always interested and willing and talking and working together to come up with language that makes sense. But I would just continue to point out that the purpose of the Healthcare Malpractice Claims Act was never, ever to cover everybody. It was to address an insurance crisis for particular types of healthcare providers. That's why it's defined as particular types of healthcare providers, and that's why there's a specific definition. So, this idea that certain people are still subject to not being able to get coverage, it's just not true. We're still willing to work with the bill sponsor to come up with language that we can all agree on. But I would just say it can't be super broad language that everybody, including independent contractors, is covered by the Malpractice Claims Act.
Well, aren't some independent contractors, like perfusionists that come from different companies to work in the hospitals, or nurses that are independently contracted, or even doctors who aren't necessarily full-time equivalent employees for the hospital, they're contract hospital doctors?
Yeah, and they're covered by the Act. I mean, I have plenty of cases against nurses who are travel nurses, or really I've named the hospital, but the care that is provided, the care at issue is being provided by a travel nurse that's an independent contractor hired by a travel nursing agency staffing a hospital. That's still under the Malpractice Claims Act. I still have to file that in health claims and then waive into circuit court. It's still subject to the Healthcare Malpractice Claims Act cap. But what we're not talking about is janitors or lobbyists. Like that was one of the things that was named, right? So those are examples of hospital employees that arguably would be covered under this act.
I don't think so, but we obviously can work together to clean the language up to make sure all parties involved are comfortable with appropriate language. But it's not to include janitors or to include lobbyists, obviously. Hence why you see the letter from different letters of support from different organizations. So I'm willing to work with you on the bill. And the same question applies to Right to Life. Whatever works for us to
I'm not sure there can be an amendment without some other bill maybe addressing the lack of accountability for prescribers of the abortion pill right now. Maryland does not require the reporting of abortion statistics, and there needs to be that connection made between whoever prescribes the abortion pills to the woman or girl receiving them, so that there should be some accountability that they have to follow that woman or girl rather than sending them to the ER to finish the abortion. There should be something like that they're required to follow them in their own clinic rather than putting that burden on the hospital and hospital personnel.
Okay. Yeah, I know.
This bill isn't very narrow. I mean, it's only 1 1/3 pages, so it's really not that. It's very broad.
Okay. So we're willing to work with you on the additional amendments as well. It's only three letters of opposition and multiple letters of support for the bill. But we are willing to work with you to come up with some clarity for everybody to be able to move forward.
I mean, that also would require the woman or girl admitting they took it, and that's a big, took the pill, and that's a big burden for a hospital or hospital personnel if they end up being held liable because of the consequences of taking the abortion pills and then the negative, the adverse events that occur afterward, that if somehow their treatment wasn't successful, but they're not the ones prescribing these pills. So transferring that liability to a hospital and the hospital personnel that did not prescribe the pill is the real problem.
All right. Looking forward to having further conversation.
Okay, thank you.
Thank you, Senator.
That'll conclude testimony for Senate Bill 681. We'll now head on to Senator Mouts with Senate Bill 797. Welcome.
Thank you, Mr. Chair, Mr. Vice Chair, colleagues. Thank you for the time to present Senate Bill 797 today. This is a delegation bill and it's coming from the Dorchester County delegation. And what this legislation would do, it would change the notice requirement where the county is currently required to provide notice once a week for 3 weeks, and it would exempt them from having to do that for property leases for 5 years or less. This is the second year we brought this bill. There's a letter of support that's been submitted from the county. And again, the delegation, it was a tough vote, but I was able to convince myself to vote for it. And Dorchester County, it's tough times there right now. They're making a lot with very little. They're facing some enormous challenges. And this seems like a minor issue, but it's something that has made it to their radar screen as far as functioning efficiently. It becomes a delay for them in trying to lease properties. They were trying to do the most with what they have available to them. And these are short-term leases. They're 5 years or less. And there have been public hearings on this now for 3 years. So it's not a new issue back home in the county. And I'd urge your favorable support for this legislation and wrap it up with that.
Excellent. Thank you very much, Senator. Senator McKay.
Senator, for bringing this bill. Being a senator of delegation of one that I am with you, did any of these public meetings, were they recorded or live with yourself?
Well, the delegations meetings can be really painful sometimes, but we set the camera up behind the mirror, so you can get all the angles.
Okay. All right. I was just actually looking for some pointers for my YouTube channel of delegation of one. Thank you.
Yeah, they voted I needed a haircut. That's how the meeting ended.
I just thought, I saw you talking to yourself, and I was like, oh, my must be having a bad day, but you're just having a meeting. You were just conducting business. It's good. All right. All right. Yeah. All right. Thank you very much, Senator Mouts. With that, if there are no further questions, that'll conclude the hearing for Senate Bill 797.
Thank you.
We'll now move on to the final bill of the day, Senate Bill 743.
Should we sit?
Yeah.
Thanks.
All right, good afternoon, everyone. Senator Smith here to introduce Senate Bill 743. And over the last couple of years, in this committee, we've actually had a lot of high-profile issues dealing with torts and tort liability and state sovereign immunity and the whole concept, obviously, with police reform and then the Child Victims Act. We had a bill that kind of adjacent to this issue with the non-economic damages with the vice chair. And so we've dealt with a lot of interesting tort claims issues in this committee over the last couple of years. And the bill before you deals with, and it deals with essentially the whole notion of sovereign immunity, which is the common law doctrine that obviously the state cannot be sued without its consent. In law school, we learned about this a little bit. The king can do no wrong, and which derives from British common law. And so it's kind of a throwback to some of those elementary lessons we learned in law school. Obviously, it typically applies to the federal government and also to state governments. But the state governments and federal governments also have the ability to remove that shield of protection. The federal government did this through the Federal Tort Claims Act. And we started this process in Maryland in 1981 with the Maryland Tort Claims Act, which is obviously the goal of that policy shift at the time was to allow for individuals that were the victims of tortious conduct from the state to seek some form of relief. And we use that Tort Claims Act, and we have continued to do that in some of these adjustments that we've had over the last several years to balance equities. Obviously, this concept exists because we understand that the federal government or the state government, they provide critical services like public safety, transportation. They help society operate. And so we understand we're trying to balance those equities between protecting those institutions so that they can continue to perform those essential functions, while also understanding that where there is a negligence in tortious conduct, that there's a victim on the other side that needs to be compensated for that. So again, most recently in the most high-profile incidents, again, we did this with the Child Victims Act, which we bumped up the Tort Claims Act to $890,000, and we did this also with police reform. So incidents involving law enforcement officers also bumped up to $890,000. The tort claims, the State Tort Claims Act caps liability currently at $400,000 for a single claimant for injuries arising out of a single incident or occurrence. So what the bill before you does, and we have some amendments that are going to make some minor tweaks to it, is that it moves the Maryland Transit Administration under the State Tort Claims Act. So that would cap that liability at that $400,000 amount that I spoke of earlier. Again, we made changes to the Child Victims Act and to the Police Reform 890. We sought an Attorney General's opinion to see if, let's say, for instance, the MTA police force had some sort of an incident, and we are advised that those new caps that we created still apply if you move MTA over. So 890 for an incident of child sex abuse, but also for police violence. So those new caps still apply if you move this over. And right now, despite the fact that MTA performs this government function, it is actually exposed to unlimited liability. This drives up insurance, and the representative here will speak to the cost of that insurance. I think it's upwards of $14 million every year. That's money that could be poured back into the MTA to provide for better service delivery, for you, me, and all of our constituents that can be plowed back. A little history as to why the MTA is probably not, why it's in the transportation article and not subject to the Tort Claims Act. So initially it was known as the Baltimore Transit Company, and the Baltimore Transit Company was a privately owned public transit operator. It provided streetcar service and bus services in Baltimore City from about 1935. It was actually subsumed into or absorbed by the Maryland Transit Administration in 1970, and that change just was never done. And that's a policy call that this body either just chose not to, didn't understand, or just chose not to make at the time. Though the MTA performs a public function and is deserving of protection, again, balancing those equities under the Maryland Tort Claims Act. I have a list of other entities that are considered to be public entities or slid under the Tort Claims Act. This is in the Maryland government, the state article. This is 12-101. Entities like the Maryland Stadium Authority, the Maryland Environmental Service, the overseas programs of the University College of the University System of Maryland, the Maryland Economic Development Corporation, the Maryland African American Museum Corporation, and I could go on. If you were to ask me, MTA seems more akin to performing a public function than almost anything else that's enumerated in this list, and I'll provide that section of the code for you. So in the interest of public policy, of resource allocation, and also balancing those equities, we think this is the right choice to move MTA under the protection of the Tort Claims Act. I think it's the best public policy for our state. And with that, I'll ask the committee for a favorable committee report, turn it over to my panelists, and I'll stand by for questions.
Okay. I'm sorry. Would you like the agency to go first, or should I go first?
Whoever
I just, only because of the background, I thought, if you don't mind, Madam Administrator. I'm John Larry. I chair the Baltimore Regional Transit Commission. I'm a private citizen appointed as a volunteer by the governor. I am a lawyer, but I don't know much about torts. If you ask me any difficult torts questions, I'm a transactional lawyer for quite a while. But the BRTC is responsible for providing oversight and advocacy for the regional transit system. And one of the things that we did in our first year of operation was to identify challenges facing MTA's cost-effective delivery of transit services and efficient use of limited resources. So I am a lawyer, and I said, well, I'm just going to go try and understand. Someone said to us, we're not covered by the Tort Claims Act, and it costs us money. And I said, well, how can that be? So I went and looked it up, and the Maryland State Law Library publishes a very nice piece on how to sue the state of Maryland, and it has a section on the state government, how to sue the state government, and then it has a whole separate section on how to sue the MTA. They're separate, and I don't know why, and I haven't been able to figure it out. But as you've heard, that effectively means that the MTA is subject to unlimited liability, as opposed to being the beneficiary of the Tort Claims Act limits. This seems irrational to me. Whatever you may think about the Tort Claims Act or tort limits or what they should be, it just simply seems irrational, inequitable to me that the MTA, which is clearly performing a governmental function, ought to be treated differently. So we wanted to bring that to the legislature's attention. Thank you very much, the Senator, for being willing to introduce the bill to try and create a more equitable treatment for MTA, which performs an important function. As you'll hear from the administrator in a moment, there are economic reasons also, and the senator alluded to them, additional costs and such that MTA must bear. For me, this began, and to some extent, frankly, ends as just a matter of simple equity. I just cannot make an argument for why MTA should be treated separately, as it has been now for decades. And I hope with this bill and the committee's indulgence and a favorable recommendation, we'll be able to change that going forward. Thank you very much.
All right, good afternoon, Chair Smith, Vice Chair Waltraker, and members of the committee. For the record, I'm Holly Arnold. I'm the administrator of the Maryland Transit Administration. I want to thank Chair Smith for putting this bill and, note for the record, as a transit provider, MTA faces unique challenges due to our exclusion from the Maryland Tort Claims Act. Currently, we're without a cap on liability, which places a significant change on resources that really could otherwise be dedicated towards enhancing our transit service for all Marylanders. This unpredictable financial burden can divert essential funding away from safety improvements, from service enhancements, and key infrastructure investments. At present, we self-insure our core modes to the tune of $5 million for incidents related to light rail or metro, and $10 million for incidents associated with core bus. And we also carry excess liability coverage up to $500 million. For fiscal year 2025, this accounts for over $14 million of our budget. Think about that. What could we do with $14 million each and every year that could be going towards additional projects or additional service? Further, MTA must also require higher levels of insurance for our contractors. So this ultimately leads to increased capital and operating costs for the agency. And beyond that, we believe that it decreases competition on MTA procurements by deterring smaller companies from bidding. We've heard directly from contractors who choose not to bid because of our insurance requirements. By narrowing that contractor pool, we can't be sure that we're getting the best value possible or that we're bringing in as many contractors as possible to participate in state procurements. I do want to know, as it stands, it won't affect MTA's obligations under federal law regarding our MARC train operations, and we will continue to meet those required insurance levels. MTA believes that this bill is a responsible and balanced approach that protects both the MTA and the communities we serve. It represents a crucial step towards strengthening our transit network by creating predictability in our budget. Should this pass, the money saved will go directly towards our core mission of providing safe, efficient, and reliable transit options to all of our riders. So based on this, I respectfully respect the committee grant a favorable report, and I'm happy to answer any questions.
Oh, thank you. I learned something every day in JPR, don't I? So I just wanted to clarify, so does the Maryland Transit Administration now, I understood it was private in Baltimore. So is it beyond Baltimore? Is it regional now? Because, that makes sense. And the follow-up question is, if it's not statewide, and it might be, I think we have other transit systems that perform a very similar function. I think Harford County has a transit system. So, and while its name is Harford County and not Maryland, you can make an argument that it stands in relative, parity with the Maryland Transit Administration. I'm not against the bill. I'm for helping. Yes, glomming on. Not, So yes.
Yes. So excellent question. So MTA is statewide. So we have our core system in the Baltimore region, but we also do provide commuter bus. So we have commuter bus that goes into Harford County and other surrounding jurisdictions, as well as our MARC train service. This bill is
so it's MARC train also. Is that right? Okay.
So this bill is specific to the MTA. So when MTA was created, there's the Maryland Transportation article, and there's a whole bunch of things in there that kind of create MTA as separate from other systems. So I believe Harford Transit would be under normal kind of governmental law.
It would be
so this
already.
Is very specific to MTA. So, but our commuter buses that we provide in Harford County would benefit from having lower insurance requirements.
And then just another one. I think you mentioned that it was costing you currently, and I'm sure you're self-insuring. I get that. But I think you indicated there were other costs. Maybe they were preventing you from doing upgrades. I'm still in favor of the bill. That's a bold claim. So I was trying to figure out are you getting lots and lots of big liability judgments that are eating into your ability to do capital improvements, or you might have even said you aren't even capable of them. But if you could just explain that a little bit more.
Sure. So we actually have our self-insurance, and then beyond that, we have to carry excess liability coverage up to $500 million. So the cost of that is about $14 million.
How much is it annually?
About $14 million annually. We also do have claims, and I can actually make sure I get the number here. Between 2021, this is calendar year, and current, we've had $16.1 million in settlements that we have paid out throughout. I will note that the majority of our settlements are very small, right? So they would still fall under.
But you have a lot of ridership.
Yep.
I get it.
Yep.
So is it your belief that with these cost savings that the MTA, and we don't have to put it in this bill, but I really would like to think that the MTA will then take those savings and do the critical, necessary, overdue, and sure customers will, improvements?
Absolutely, yeah, and that is the intent of the bill, and we appreciate the chair for recognizing that and putting it in. We can put it directly back into providing better service, improving reliability, improving safety of the system.
All right, thank you.
Thank you to the chairman for the bill. I think the senator was kind of squinting at something that I want to follow up on, which is I agree 100% with Mr. Laria. This is inconsistent with everything else we do. But actually, Administrator, this question is for you. I mean, what you guys have unintentionally is essentially a natural experiment for what the uncapped world looks like. And so as you guys have done your financials, so you're paying $14 million now for insurance. What is your estimate of what you will pay annually for insurance once the cap goes into place?
I can follow up and get you specifics of what we think that will be. I will note insurance costs are continuing to rise, so that is going to be a little hard to predict, but I'm happy to follow up on that.
Okay.
It's also difficult to predict, but we do fully expect to see savings as well on the capital side by hopefully getting more bids, more competitive bids, and bringing in some of those smaller minority-owned business on the construction side to bid on that when they don't have that $5 million in insurance that we require them to
I understand this is like highly imprecise and that you'll get me more firm, but is your sense that you'll save 5%, 10%, 50%? Like where, of the 14 million, what as a percentage?
We anticipate millions in savings every year, but I can get you the specifics on that.
Gotcha. And then going back to the 16.1 million and kind of this natural experiment, how many claims in that period of time were above what this cap would be?
Let me give you the specifics on that as well. Again, the average is pretty low, but I can give you specifics.
And just so to clarify for the data to come, not how many claims were made, but how many claims were settled
paid out. Yes,
or a jury finding above the capped amount.
Yes, absolutely. Yes.
Gotcha. Any further questions for the chairman or this panel? If not, thank you so much. Really appreciate it. All right, we'll now take the unfavorables. I have Ms. Clark and then one online, my constituent, Mr. Mitchell. Mr. Mitchell, hold on one second here. We're going to take Ms. Clark first.
Good afternoon again, Mr. Chairman, Mr. Vice Chairman, members of the committee. Again, I'm Patrice Clark. I'm here on behalf of the Maryland Association of Justice, and we urge an unfavorable report on Senate Bill 743. We all know that the MTA, the Maryland Transit Administration, is not like all government administrations. It's not the Treasury Department. In fact, the last time a version of this bill was introduced was in 2021, and the MTA asked for a cap of $800,000. And by the way, in 2019, they asked for a cap of $1 million. In 2007, they asked for a cap of $1 million. So I'm just pointing that out. But when they introduced this bill in 2021, they submitted a letter that said that they recognized that the MTA, quote, operates, Senator Folden's not here, he made fun of me for the air quotes, operates modes of transportation that can pose a risk of severe personal injury. So they recognize that. And that's why the MTA is subject to a separate cap. The MTA provides millions of rides every week, every single week. And yet, at least according to what I could find on Judiciary Case Search, the MTA is rarely subject to claims. And this goes to what Senator James was asking. For example, in 2022, I found 9 personal injury claims on Maryland Judiciary Case Search. In 2023, there were 12. In 2024, there were only 4 personal injury claims that actually made it to Maryland Judiciary Case Search that I could find. Personal injury claims against the MTA are exceedingly rare, particularly when compared with how many millions of people ride MTA every single day. Finally, I want to point out that limiting the liability of the MTA does not limit independent contractors. Under Maryland law, one who engages an independent contractor is not liable for the negligence of that independent contractor. So a third-party vendor wouldn't be limited to the Maryland Tort Claims Act cap. In short, when Maryland citizens are injured because of the negligent actions of the MTA, we should protect the citizens, not the MTA. Thank you.
All right, Mr. Mitchell, welcome. You are up next. All right, hold on. You are muted. Let's get you unmuted here. All right, there you are.
That should do it. Thank you to the chair, to vice chair Walt Stryker, my own senator, and to the entire committee. My name's Dennis Mitchell. I'm here in opposition to Senate Bill 743. The bill would subject Maryland residents to risks that passengers in our neighboring jurisdictions don't face. Briefly, I'm a lawyer practicing in Maryland, DC, and Virginia. I'm barred in all 3 states. I represent people who've suffered serious injuries, mostly in transportation circumstances or medical negligence. I'm also a Kensington, Maryland resident and a regular user of Metro Rail, Metro Bus, and Ride On. In fact, I've sat next to then Representative Walt Stryker on a Metro train, and we had a little redhead moment where we both talked about, and I remember thinking, what a great place where me and a fellow redhead who's also my rep can meet on the train. In any event, we were reminded this past January of the catastrophe and life-changing results that can happen from time to time in public transportation. And when that happens, families are deeply affected. And it seems to me that transportation belongs in a different box than some of the other things the state does because of the potential for catastrophic injury that lurks around every corner. And the present bill would limit the recovery of injured commuters to $400,000. That is far less than they would recover if injured by WMATA, if injured in a plane crash, if injured by Amtrak. So why are we going to take one group of commuters and subject them to having no recovery if their lives are permanently and irreparably harmed, whereas another group of commuters would have a decent remedy, a chance to put their life back together? And when you do this work for families, you can't help but think to yourself every time you do it, it's one of the risks that, gosh, what happened to these poor people could happen to me. I'm representing a plane crash victim now, and I've represented people who were killed in Amtrak crashes. And when you think, gosh, that could just be me going to work, how would my family recover? I'm telling you, $400,000 would not let these families recover. It's just too much at stake. And for that reason, I ask the committee to give this an unfavorable report.
Excellent. Thank you very much, Mr. Mitchell. Questions from the committee? All right, seeing none, thank you very much. With that, that'll conclude the hearing for Senate Bill 743 and our hearings for the day.
Thank you.
Hooray, hooray, it's light outside.